Good afternoon. Welcome to the Appellate Division First Department 2.0. The court is now in session. I will begin by the call of the calendar. First case, People versus Dwight Reit. Appellant Reit has been allocated 5 minutes and one in rebuttal. The people get 5 minutes. Burton versus Davis. Appellant Burton gets 5 minutes and one in rebuttal. Respondent gets 5 minutes. W. Children is submitted. Valentino USA versus 693 Fifth Avenue. Appellant Valentino gets 6 minutes and one in rebuttal. 693 respondent gets 6 minutes. People versus Brian Grant is submitted. Moelis and Company versus Auquin Financial. Appellant Auquin gets 6 minutes and one in rebuttal. Moelis respondent gets 6 minutes. People versus Cesar Pimentel is submitted. I apologize for that. So People versus Pimentel is submitted. Brown versus Sureguard Storage. Appellant Brown gets 5 minutes and one in rebuttal, and Appellant Sureguard gets 5 minutes and one in rebuttal. Vertical gets 5 minutes. Public Administrator of Queens versus 124 Rich. Appellant Administrator gets 5 minutes. 124 Rich gets, they get 5.5 minutes and one in rebuttal. 124 Rich gets 5 minutes and one in rebuttal. Kaiser also gets 5 minutes and one in rebuttal, as they all appellants. S. Travis is submitted. Marcar Finance versus Sutton Middlegate. Appellant gets 5 minutes and one in rebuttal. Respondent gets 5 minutes. Coylan versus KPP and Impact. Appellant Curling gets 5 minutes and one in rebuttal. Each of the two respondents gets 5 minutes. Garrido versus de Blasio. Petitioner Garrido gets 6 minutes and one in rebuttal. Respondent de Blasio gets 6 minutes. Hand versus Stonehouse Properties. Appellant Hand gets 5 minutes and one in rebuttal. Stonehouse gets 5 minutes. Mohinani versus Charney. Appellant Mohinani gets 5 minutes and one in rebuttal. Respondent gets 5 minutes. Singh versus Genovese submitted. Johnson versus Montefiore Medical is also submitted. First case on the calendar for argument is People versus Dwight Reit. Let me first hear from Appellant Reit.
Good afternoon, Your Honors. Can you hear me, Judge?
Good afternoon. I can hear you.
Great. Thank you. Richard Greenberg for Dwight Reit. Your Honors, Dwight Reit was denied his Sixth Amendment right to a public trial when, in the middle of this case, the court abruptly closed the courtroom to all spectators for the remainder of the trial. In doing so, the court failed to hold a Hinton hearing or conduct any inquiry whatsoever. The court,
Counsel, is that argument preserved? Didn't the court give an opportunity for the party to respond, and was there any alternative other than what the court suggested with regard to the closure of the courtroom?
if I understand your question, regarding an opportunity, yes, defense counsel was, after the court closed the courtroom, after the court issued its order, defense counsel objected. And he proposed a reasonable alternative to the problem, which was apparently that someone had taken a photograph on a cell phone in the courtroom. And he said, why don't we just bar cell phones? But even backing up from that, Your Honor, we don't even get to reasonable alternatives because the court never made any kind of finding that there was a compelling overriding governmental interest that was likely to be prejudiced absent closure.
Mr. Greenberg, wasn't there all the conduct in question other than the taking of photo?
Well, Your Honor, that's an interesting question. Despite the rhetoric that pervades respondents' brief, there really was none. The judge referred to spectators staring. But what does that mean, staring? Spectators are entitled to stare.
Didn't the judge articulate that she personally felt intimidated and that other people, including the court reporter, felt intimidated by the actions of the spectators?
Well, let me respond, Your Honor. The judge did say she felt there were intimidating stares, but she did not specify who was doing that or what was intimidating about the stares. Nobody was threatened here. Not a single witness, juror, court personnel, or anyone else involved ever complained about a threat or intimidation. And with regard to the incident involving the court reporter, that took place outside of the courtroom. It took place in an elevator. We don't know who was involved in that.
Does it matter that it took place in the elevator, given the fact that the court reporter stated that the individuals who engaged in this conduct were the same individuals who were later in the courtroom or ultimately in the courtroom? Well,
Justice Weber, we don't even know that. What we know, because we never heard from the court reporter, what we have is the judge's recount of what allegedly occurred. And all that occurred was that there were people, and we don't know who they were, in an elevator who invited the court reporter to get on the elevator.
We do know what occurred because apparently the court reporter specifically related the incident and the quote unquote conversation to the judge and told the judge exactly what had occurred in that elevator as she was attempting to enter the elevator. And it was a little more than inviting her in. It was also a statement, I believe, why are you afraid of us? Which I think maybe the court reporter could see as being somewhat intimidating.
Judge, as I understand what happened is the people in the elevator invited the court reporter to get on. She declined, and one person apparently said, why, are you afraid of us? And that was the end of it. Now, I'm not saying the court reporter didn't somehow feel, upset in some way, but that incident alone cannot justify the blanket exclusion.
Exactly, and so it's not that incident alone. I think what Justice Kern was alluding to is that it was the totality of the circumstances. It was the incident as to the court reporter. It was the incident as to staring of the individuals within the courtroom. It was the incident as to staring of the judge while in the courtroom.
Right.
So it was everything.
There was some of the conduct was observed by the court itself, right? It's not just what the court reporter related and the court officers, etc. The court herself saw what was going on.
But Your Honors, the court merely said, I feel that people were staring. That is never.
Just go back to this mix is the fact that you have photos posted online. Added to this mix is that you have photos posted online with, among other hashtags, watch who you offend. So you add that to the mix. You say there were no threats. There are these threatening message being sent, and that emerges from photos being taken in the courtroom.
And with regard to reasonable alternatives, there was never any, there was something with regard to taking the person out, but without knowing who was taking the photos, no one really knew who was taking the photos. So what was the reasonable alternative that was given in light of that?
But Your Honor, that's exactly the point. We don't know who. The judge acted so.
Which is why there was no reasonable alternative offered by the attorney when he said, well, just take the person who was doing the photos, take them out.
No, what the attorney suggested was bar cell phones from the courtroom. Since you were going to stage a court officer at the door to bar everyone, Why not let people in, but make them?
How would that have, Mr. Greenberg? How would that have resolved the issue, the staring issue, and some of the other conduct the court observed? See, that's the problem. That it wasn't just the cell phone; it was the posting, as Justice Friedman pointed out, the posting of some of those photos online with some, I don't want to call them threats, but concerns being raised.
We don't have any factual record as to any of this. When the district attorney made the application, she said, "I've just been informed that someone posted a photograph online that was taken in the courtroom. I haven't even investigated it yet. I don't know what the extent of it, and I don't know who did it." And the judge said,
How did you expect this, making sure that no one has a cell phone in the courtroom? How is that going to work out? You were going to have the court officers search everyone walking in to see if they have a cell phone? Is that what you're suggesting?
I'm saying that it would be very easy to have people give up their cell phone like they do in federal court. No attorney brings a phone. Nobody brings a phone into a federal courtroom. Everybody gives up their cell phone.
No attorney is bringing a cell phone into the room. But I don't think that the people who were taking these pictures were attorneys.
I'd like to just remind the court, prior to this application by the district attorney, there had not been a single incident in this courtroom. There had not been a single complaint by anyone of intimidation or threats or staring. The judge.
But what difference does that make when there were postings on the web and the judge herself made statements? What difference does it make what happened before?
We don't know what postings were made. We don't know who made them. We don't know anything about anything.
Thank you, Mr. Greenberg. Thank you, Mr. Greenberg. We've gotten about 7.5 minutes on this one, so let me hear from the people.
Thank you, Your Honor.
Thank you, Justice Acosta. Good afternoon, Your Honors. May it please the court. David Cohn for the people. To begin, the arguments that the defendant is making to this court have not been properly preserved for review. In the court below, the defendant did not dispute that this conduct occurred. The defense did not dispute that there was intimidation. The defendant did not dispute that there was staring. The defendant did not dispute the judge's account of the incident with the court reporter in the elevator. The defendant did not dispute that the court reporter was intimidated. And the defendant did not dispute that there were pictures taken in the cell phone and there were photographs of the court proceedings posted online with various hashtags, including Free Dick Wolf, which was the defendant's nickname. So there was absolutely no dispute that any of this conduct occurred. In fact, the defendant did not dispute below that this conduct combined cumulatively justified some action being taken to protect the courtroom from the specter of fear and intimidation. And the defendant did not dispute that the overriding interest test of Waller had been met, and the defendant did not ask for a fact-finding proceeding of any sort. The judge made these findings on the record, and they were uncontested. The only thing that the defense counsel asked for below was for a reasonable alternative to be imposed, that a court officer would stand outside the courtroom and confiscate cell phones. As some of your honors have noted, that would not have solved the issue of the intimidation that had been happening. And also that would have been very, very difficult to institute. There's not normally a metal detector set up in the state courthouse outside the courtroom. And the idea that you would personally search each person walking into the courtroom for possible recording devices, that's something which would be...
I want to turn your attention to another issue in the case. You concede that the 50-year to life sentence can stand, but yet you don't agree to the sentence just being reduced to 25 to life. How do you propose to have that 25-year reduction restored?
Justice Friedman, the Court of Appeals has stated that in a situation where the trial judge runs the wrong sentence combination consecutively, but clearly expressed on the record their intent that there should be consecutive sentences. And here, Justice Pickles, this is one of the most disturbing crimes that she's ever been involved in in hearing the case as a judge. This court has the discretion under People v. Rodriguez to send the case back to the trial court and remand for the trial court to consider in the exercise of its own discretion whether it wishes to rearrange the sentence to a different sentence.
Sorry to interrupt.
I'm sorry, Justice.
What evidence do you have that I think it's the count 3, would be able to be run consecutively to count 1? I mean, what evidence do you have about where the gun came from, when it materialized? What do you have that would allow that count to be run consecutively?
Yeah, well, Justice Renwick, thank you for that question. So on this record, we know that the defendant had the gun at some point before he entered the bar. There's surveillance. There's no indication that he just picked up a gun right before firing the fatal shot. So he either had the gun when he walked into the bar about an hour before the crime, or when he walked out of the bar before walking back in a few minutes before the crime, he might have walked out and picked up the gun at that point. So we know at the very least he retrieved this gun a few minutes or a few minutes before firing the fatal shot. Under People v. Malloy from the Court of Appeals, 33 New York 3rd, 1078, consecutive sentences for murder and simple possession of a firearm were held appropriate where the defendant was in the possession of a gun several minutes before approaching the victim. Your Honor, we submit that that case is analogous here, and that on this record, the trial judge, if she so desires, could have made a finding that the simple possession of the weapon was complete before the murder, and therefore consecutive sentences were appropriate for murder and simple possession. All we're asking this court to do is send the case back to the trial judge to make a determination on that issue, and make a determination as to whether her sentencing. Oh, sorry, Justice Acosta.
No, I'm sorry. I interrupted you. So your time ran out a while ago. So thank you.
Okay.
Let me hear
right.
Mr. Greenberg. I'll give you 1 minute rebuttal and try to let you get a word in for that minute. Obviously, we all feel strongly about this case.
Well, let me just say this, Your Honor. The court below made no effort whatsoever to identify anyone who was, in fact, acting in an intimidating fashion. Instead, she closed the courtroom to all persons, including the family of the deceased. Now, Mr. Reit has a right to a public trial. It's a basic fundamental right. There is not a single case that I'm aware of or that respondent has cited where a judge has closed a courtroom or closed a trial to the public for the entire trial and closed it to all persons. There's nothing like that. The cases that courts in this state have allowed closure have been where there, A, has been evidence of actual threats made to witnesses or actual intimidation, not just allusions to it. And even in those instances, only the offending persons were removed from the courtroom and only for the time necessary. For example, if there was a witness who was afraid to testify. We don't have any of that here. This would be an
unprecedented. He didn't close the courtroom for the entire trial. He closed the courtroom because of circumstances that had developed during the trial when the courtroom had been open.
And the judge made no effort to distinguish between those people who might have been acting improperly and those who were there in the courtroom just observing the proceedings. Instead, she just closed the courtroom to everyone. That's
Counsel,
just
do you want to spend a few minutes on the consecutive issue?
Judge, I would just say that the case law is very clear. Under the Court of Appeals case, People versus Brown, the people would need to show, and there is no evidence whatsoever in this case, that Mr. Reit possessed a gun prior to forming the intent to use it unlawfully. And in this case, the only evidence of a gun.
I mean, you know, Mr. Greenberg, having watched the video of the shooting, you know, clearly the defendant walked in with the intent. You see him looking around until he spots victim Wallace. So he walked in with the gun, and clearly his intent when he was holding that gun before he actually did the shooting was to use that gun in the murder. So you can't get consecutive time. I mean, the people concede you can't get consecutive time on the intent to use unlawfully, but it's whether he possessed the gun in a place other than his home or place of business. Which, again, it's a fair inference from what you see on the video. You could make that inference. He had the gun before.
Your Honor, I think that there's an additional requirement. It's not just that he possessed the gun outside of his home or place of business, but that he possessed the gun at a time before he formulated the intent to kill. And in this case, the only evidence is that by the time he got the gun, because he didn't have it apparently when he was in the bar, he had a fight. Apparently, he made up his mind, I'm going to get this guy, walked out of the bar, retrieved the gun, came back in and shot him. So the only evidence we have is that he possessed a gun at the moment when he had the intent to use it unlawfully, and therefore consecutive sentences would clearly be illegal, even for the simple possession charge.
Thank you, Mr. Greenberg.
Because the possession with intent is a more serious charge than simple possession.
I think we got your argument. I thought you were just going to say yes to Justice Friedman's point. So
Thank you.
Thank you both. Burton versus Davis.
Good afternoon, Your Honors. May it please the court. Michael Zhu, Appellate Counsel, the Lesh and Lesh attorneys of record for the plaintiff, Lambert Burton. We believe that the trial court erred in denying the plaintiff's motion for partial summary judgment as to the issue of liability, and the order should be reversed. The issue really comes down to whether at the time of the incident—
Is there a section of the VTL that was violated here?
Yeah, I believe it was,
that there are no issues of fact?
Yes. The defendant failed to yield to the right-of-way and made a right turn from a left-hand—
Couldn't that be said for both parties?
No, because the plaintiff was the one who had the right-of-way because he had a green light and he was proceeding straight at the time. So a defendant—
But that's not defendant's version of what occurred. Whether it's true or not, obviously, there's no way of knowing. But doesn't the defendant have your client? Yes, the light is in your client's favor, but then your client's not moving. And he says he was on a cell phone. And so that's when he pulls that around him. That wouldn't constitute a violation if that was true. How does that get you to summary judgment?
I still believe it violates the VTL, Justice Friedman, because he, meaning the defendant, is to the left of the plaintiff. He is seeking to make a right turn.
Behind a car, if you're behind a car that's not moving, and you've got a green light in your favor too, you're not permitted to pull out around him and go forward? I mean, what if the car is disabled? Certainly, sure. You don't have to just stay there.
Well, understood. But again, that those aren't the facts here. Meaning that the plaintiff didn't have his hazards on, so his vehicle was not stopped.
Well, did the defendant blow the horn or do anything to alert the plaintiff before he went around him? Did you plead the VTL that requires a turn to be from the utmost right turn if you're making a right turn? Did you plead that section of the VTL?
I'm not sure if it was pled in the pleadings, but it was certainly alleged as a predicate for the motion. That
I don't understand what you mean. It was either pled. I don't see where it's alleged or anything else that says. I think it's 1160.
Yes. So the 1160 is that you could make a right turn, but only if it's safe to proceed. And the argument here is that it wasn't safe to proceed because he didn't have the right of way to make that turn as the plaintiff.
Well, that's your argument that it wasn't safe to proceed. The other side is arguing that your client waited 5 to 10 seconds, and that they proceeded to go around him and then try to make the right turn, and that's when your client decided to step on the accelerator.
But look, Judge Acosta, I appreciate that, and even if I can see that the plaintiff was wrong in his recounting of the facts, and that instead of being the first vehicle in line at the light, he was the third vehicle, and we accept the defendant's version and view these facts in the light most favorable to the defendant, it still is undisputed that the plaintiff had the green light and he was moving straight. So,
but he was not moving. Well, he had the green light, but he was not moving.
But at some point he was. Otherwise, there wouldn't have been a collision. If the plaintiff was behind you.
So if you stop and you have a red light and you're fidgeting with your cell phone and will not advance for 5 to 10 seconds, you're saying that the only recourse that the folks behind your clients have is to wait for him to finish whatever it is he was doing with the cell phone.
No, of course not. No, Judge, that's not my argument, because then that would be silly to make that argument. The point is that these two vehicles were not proceeding straight, right? The point is that the defendant was attempting to make a right turn from the left-hand lane, and he had a vehicle to his right. So at some point, the vehicles collided, which meant that my client's vehicle was moving at the time, which meant that he was not stopped, and the defendant did not completely overtake the plaintiff. There's a collision. So at some point,
where he thought his argument is, or what he says happened is your client wasn't moving, so he's trying to get around him in order to make the right until the garage, and your client all of a sudden accelerated. But
isn't there a requirement that you have to make a right turn from the rightmost turn lane?
Yes, there is.
Assuming there's no obstacle, right?
Correct. And so here the defendant did not make a right turn from the rightmost turn lane. He made a right turn to the left of the plaintiff's vehicle, which was moving
he
forward.
says because your vehicle was blocking the way. He was trying to get into the parking lot, and your client's vehicle didn't make that possible, so you had to go around him, if that's true.
So even assuming those facts, if he's making the right turn from the left, my vehicle, the plaintiff's vehicle, had to have been moving forward for the collision to happen.
So isn't the bottom line therefore that there are issues of fact?
As far as the plaintiff's concerned, he had the right of way, so the defendant had to yield to his right of way.
I think we got your point, Mr. Zhu. Thank you.
Appreciate it.
Let me hear from the respondents. Counsel for Mr. Davis.
May it please the court, as counsel for DR Rasuba and Drop Car, it's very important in this case to be mindful.
Counsel, I have a question for you.
Sure.
Was your client in the rightmost lane when he made that turn?
Yes, Your Honor. Section 1128.
How was he in the rightmost lane if he left the lane he was in to go around another car?
VTL refers to clearly marked lanes. If they wanted to say, or a lane that's wide enough that you can consider it to be multi-lane, they could have said it. They said
no, that's not what I don't think that's what I asked you. I asked you if your client was in the rightmost lane when he made that right turn.
Yes, he was, because there was one lane in that direction, and he was able to make the turn without leaving the lane.
So he didn't go around another car?
That's correct, Your Honor. The lane was wide enough. 1128 speaks to two or more clearly marked lanes. There was one clearly marked lane heading in that direction, and there was a stationary car there for an extended period of time.
Okay, when you say a stationary car, I mean, whether there's an issue of fact here, that your argument is that there is a car at a green light and that it's paused for a few seconds, that your client doesn't blow a horn, he doesn't do anything, that a car can leave a lane of traffic to go around a car that is clearly only stopped for the purposes of the red light before it turns green? Is that what you're saying? That's okay?
No, Your Honor. When you see what the plaintiff said on page 34 of the record.
Did your client blow the horn, by the way? Did he
There's no record of the horn having been blown. The plaintiff says that after the light turned green, I lifted my foot off the brake and proceeded to go straight. Then he noticed somebody in the rearview mirror, 5 to 6 cars in a supposed left line of traffic, swerve to the left, cross over solid double yellow line, and how he could see solid double yellow line with 2 lines of traffic behind him.
Your client's version is that he was in the lane. Your client says there was one lane. He was in the lane and he went around a car that was stopped at a red light because the car didn't move quickly enough.
No, he didn't say that. With all respect, he said that the light turned green and plaintiff waited for 5 to 10 seconds.
That's
didn't
right.
say that
So
he
he
was
was at a
stopped at
red light, the light turned green, and the car didn't move quickly enough.
Well,
5 to 10
5 to 10
seconds, he chose to
seconds.
go around it.
5 to 10 seconds of no movement at all with somebody reading a phone in their lap. And then again, it's not a violation of any VTL section. It says a vehicle shall be driven entirely, as nearly as practicable, entirely within a single lane. And if there's a stranded car on the side, that's an issue what's practicable.
What evidence is there that the car was stranded? Did he
Well,
even blow
you
the
know,
horn? By his,
well,
excuse me, by his admission, the car was at a red light. It was stopped at the red light. Anyway.
No,
mind.
he said the light had turned green and all of the other vehicles had proceeded onward. So when this happened, the car had not been stopped. The car may have been stopped, but the light was not.
If every car that was stopped at a red light, when the light turned green, people started going around the cars without a horn or anything else, we'd be in the wild, wild west driving. That's your argument, is that it's okay for your client to do whatever he did. Anyway.
So the plaintiff's version of the accident, is it that the defendant pulled out, crossed over, and turned around on the other side?
It's in the affidavit as the plaintiff started moving, proceeded to go straight, and that's throughout the brief and the affidavit.
I'm talking about what the plaintiff says the defendant did.
The plaintiff says the defendant was far behind him, and the plaintiff saw him in his rearview mirror go completely around a line of cars in back of and to the left of plaintiff, cross the double yellow line. Again, respectfully, there's no way he could have seen that double yellow line in his rearview mirror with another line of cars to his left.
But then he says, but then he says the defendant turned around.
He said the defendant went over the double yellow line, went all the way past 5 or 6 cars, and then turned in front of all these cars, which, again, in his affidavit, he says, cut in front of the vehicles that were waiting at the light. But this is subsequent to plaintiff saying that he had been proceeding forward, and he noticed it in his rearview mirror. So why all this other supposed line of cars would have been waiting is a mystery. And then he said he cut in front of that line of cars who evidently had been sitting there for a long time too, and plaintiff's account.
But anyhow, the two litigants, the two sides present starkly different scenarios of how this accident happened.
To put it mildly, Your Honor.
Thank you, Mr. Gustafson. Let me hear from Mr. Zhu. You get 1 minute.
Sure. Justice Friedman, just to clarify, the plaintiff said that the defendant's vehicle crossed over the double yellow line and then did not proceed to turn around, but he made a right turn from the left-hand lane.
How did he see that in his rearview mirror?
Well, no, he doesn't. He doesn't have to see the right turn in his rearview mirror because it happens right in front of him.
Crossing the double yellow line, 5 vehicles back?
Sure. I don't know how wide his rearview mirror is. There are rearview mirrors where you can see 5 or 6 lanes, but that's besides the point.
It was a wide street. Is that something we could all agree to? It really wasn't just like a single lane roadway.
It was not a single lane, Your Honor. Yes.
Counsel, even if we take the defendant's version,
yes.
You can take the defendant's version. He still made the left turn, a right
Correct.
turn from the left of the plaintiff. But there are questions of fact here, no question, because I don't believe that you've pled any section of the VTL that shows that it's a violation as a matter to make that right turn from a left lane.
But Judge, even if I don't have any VTL statutes pled, it's still a violation of the common law. The rules of the road say that you cannot make a left turn. I'm sorry, that you cannot make a right turn from the left lane or from the left of a vehicle that's moving forward.
Thank you.
Thank you.
Valentino, USA.
Good afternoon, Your Honors. May it please the court, Jared Kasanoff, on behalf of Appellant Valentino, USA. Your Honors, this is a commercial lease dispute arising from Appellant's termination of its lease based on the doctrines of frustration of purpose, impossibility of performance, and
Counsel,
constructive eviction.
haven't-
Yes, Your Honor.
Counsel, haven't? Hello?
Yes, Your Honor.
Counsel, haven't we already here in the First Department decided cases that have similar facts in terms of frustration of purpose and impossibility?
Excellent question, Your Honor. Although I understand that this court has addressed frustration of purpose arguments a few times during the pandemic, in some cases even cited by my adversary, this case differs from those for two crucial reasons. First, in this case, unlike the others cited by my adversary and the others that were before this court, appellant's claims were dismissed on a pre-answer motion to dismiss, without permitting any discovery on appellant's claims, and despite the fact that appellant's causes of action were pled properly. There's no dispute on that. Then that is the standard on a motion to dismiss. Second, Your Honor, this court, the lower court, I should say, didn't even get to the issue as to whether appellant met the standard for pleading a frustration of purpose or impossibility of performance argument. Instead, the court dismissed appellant's claims based on a single lease provision, and that provision is section 21.1.
Right. Well, that brings me to my question, Mr. Kasanoff. Doesn't 21.11 of the lease allocates the risk in the event that the plaintiff will not be able to operate?
No, Your Honor, it does not. That section,
why not?
It's in record page 55, is entitled Unavoidable Delays and Postponement of Performance. The entire purpose of that paragraph, Your Honor, is to excuse the late performance of a lease obligation, albeit, except for the late payment of rent, if the delay is caused for certain reasons, such as strikes, labor troubles, riots, insurrection. It almost presumes that the tenant remains in possession, but is merely delayed in its ability to perform, which is not the case here. Appellant is not in possession.
He also says acts of terrorism, acts of God, floods, hurricane, windstorm, fire.
Well, first of all, pandemic.
You don't think pandemic is encompassed within that risk allocation?
I don't think an unforeseen pandemic to the extent that COVID-19 was.
But just a second, that provision also says 21.11 also includes among the items governmental laws, or restrictive governmental laws or regulations.
Okay, so two things.
And that's what you're talking about here. The government said you could not continue to operate these businesses as you had in the past. So what emerged here is covered by 2111. And then it goes on to say, notwithstanding the foregoing after the commencement date, which state shall be subject to an unavoidable delay, nothing contained in this section shall operate to excuse tenant from the prompt payment of rent. It very much covers the situation we have here.
Well, I would disagree, because I think the COVID-19 pandemic, first of all, was unforeseen. And if it's an unforeseen event to the level that COVID-19 was, it can't possibly be included. But putting that aside, Your Honor.
Okay, Counsel, just one other thing, just expound on just one other thing. It also says, or other reason of a similar or dissimilar nature beyond the reasonable control of the parties. So all of that, again, taken together, restrictive governmental laws and regulations, the portion that Justice Acosta read, again, why would not the pandemic fit into 21-11?
Again, Your Honor, to the extent it's unforeseen, it can't possibly be included. A party cannot waive a right.
Beyond the reasonable control of the parties.
But putting that aside, I'd like to move on from that. If you look at that,
Counselor, that argument seems to me to have a weakness to it. Among the items listed here are acts of God, and obviously acts of God is not going to be something that someone can know is going to happen.
Mayor, Your Honor, in addition to the fact that we don't think it's there, if you look at the clause, the only thing that it potentially precludes is an excuse based upon the payment of rent. But here, a review of the complaint, which is record 115, demonstrates that appellant's causes of action don't concern, we're not seeking to delay the payment of rent here. Our causes of action primarily concern rescission of the lease and the guarantee. We're not seeking to delay payment of rent. Our first cause of action seeks termination, rescission of the lease based on frustration. The third cause of action.
Mr. Casanova, was your client able to continue to do some business, albeit not all of the business that you wanted, but you were still able to do some curbside retail, right?
Well, first, Your Honor, it's our position that that question is premature on this motion. The court didn't even get to that question. They just dismissed it based on this provision. But our position is, putting aside the prolonged closure of the store due to governmental regulations and the pandemic itself, even when those restrictions were lifted, it could not perform, it could not operate in the manner encompassed in the use clause in the lease.
Okay. Thank you, Mr. Casanova.
Thank you.
Let me hear from the respondent.
Good afternoon, Your Honors. Please the court, Robert Cyrulli from Cyrulli Shanks on behalf of respondent.
Mr. Cerulli, I could barely hear you. You're very distant.
I apologize, Judge. Is this any better?
Yeah, that's a little better.
I'm in a unique position today. Not every decision that's favorable to one's client is
opposing counsel seems to be saying that we really are not interested in 2111 because this is not about rent. This is about just rescinding the lease. And 2111 deals with what you do about rent because of problems that emerge.
Well, Judge, I would answer that two ways. First of all, there are actually two lease provisions that apply here and directly on point. 2111 was one, the unavoidable delays. The second was 9.1, which dealt with governmental actions broadly described, and that they were to be obeyed and observed by the tenant at their cost and expense. So really, this is two different causes that are aligned with two different lease provisions. The pandemic clearly itself falls under 2111, and the resulting executive orders that resulted in all of an approximate 90-day shutdown of the appellant. And we know that because in the record, there's an affidavit of the CEO of Appellant that acknowledges that we're back up and running on some basis, as Judge Acosta said, in June of 2020. So those two provisions prevail. As to the concept of rescission or termination, it's inconsistent with the thought that in a sophisticated party, commercial document, attorneys all around, that the parties would have bargained for an allocation of risk where the tenant can't stop paying rent, where the tenant must follow all governmental rules and regs, its cost and expense, but yet somehow the tenant would be entitled to terminate the lease or rescind the lease by virtue of the very same indicia. It wouldn't make intellectual sense, and it wouldn't make sense in the course of what's bargained for in a commercial lease.
The record doesn't reflect anything, does it, on whether the governmental assistance that was afforded to businesses during this time provided any assistance for the plaintiff?
Not to my recollection, Judge. What we do know is the plaintiff acknowledged that they were back in business. They were down from the date in March when Governor Cuomo issued his executive orders. They were up at some point. June 22nd seems to come to mind, but it is in the record as to the date that the CEO of Appellant acknowledges they were up and running. He complains that it was somewhat akin to, I think it may have been 558 7th, somewhat akin to that case where he was up and running only by curbside or some lesser degree than a fully open retail.
Well, that's the whole point. He's alleging that he was not able to. They were not able to carry on the business as they had previously carried it on, nor in alignment with the purposes of the lease, because he could only do curbside and he can only do by appointment. But you just said that it doesn't make sense that in terms of one section as opposed to the other section, in terms of rescission as opposed to non-payment. But whether it makes sense or not, don't we still have to look at the lease agreement and wherein it may not make intellectually it may not make any sense? We still have to look at the lease agreement, right? And your adversary is still arguing that the lease agreement does in fact allow for rescission.
No, with all due respect, Judge, the lease agreement by its terms, by its express terms, does not allow for rescission. Quite the contrary. The point is that the lease...
Point. Your adversary is arguing that it does allow for rescission. So that was my question to you.
Judge, with all due respect, the record will speak for itself. The lease is in the record. It makes no such mention of it. What it does mention is that in the event of these unavoidable delays, of which the case law that precedes us is well developed, that says that where a number of unavoidable delays were listed and where there's broad, almost saving language, as we have in the unavoidable delay provision, a pandemic is deemed by the parties to have been foreseeable because they are deemed to have been able to bargain for an allocation of that risk addressing it. And the savings clause, to some degree, even does allocate that risk, and it allocates it to the tenant in that it's got to keep paying its rent. And 9.1 allocates it to the tenant by, if there are governmental rules, regs, decrees, let's call them broadly, they must comply and they must do so at its expense. So there is no right of rescission in the lease. There is no right of termination on the part of the tenant. Thank you,
Mrs. Cerulli. Okay, you get 1 minute rebuttal, Mr. Kasanoff.
Thank you, Justice Acosta. I believe, Justice Weber, you hit the nail on the head. My adversary would like to read section 21.11 as a broad waiver of all claims, rescission. But
Counsel, let me interrupt for a minute. It may be that there's no lease provision either way about termination. I think your real argument is frustration of purpose, the doctrine of impossibility, which are not lease provisions. They're legal doctrines. And somehow you're trying to argue those give you the right to terminate the lease. But both of those are extremely narrow doctrines. And where on this record, where there's no question you're now back in possession of the premises, how could it possibly be either frustration of purpose or impossibility? You're clearly back there now, and it's a long lease.
We're not back there. We've surrendered first of all, because we believe that the lease was permanently frustrated. But again, as I mentioned to Justice Acosta earlier, I believe that question is premature. The court did not even get to that question at this point. And that's a factual issue. It's a factual issue as to whether or not, in this case, the facts permit a frustration. I agree it's a narrow doctrine, but that doesn't mean that the court could just eschew any analysis of it. I think it would be improvident and inequitable to set a precedent where these claims are dismissed on a pre-answer motion without any inquiry as to their merits. I think it's clear from the court's other holdings in Jack Kelly Partners, which is 140 AD 3rd 79, that the court never intended to impose a blanket prohibition on frustration of purpose claims due to the COVID-19 pandemic. I really think there needs to be an analysis of the facts, and we need to get to that.
Yeah, thank you, Mr. Kasanoff. Thank you both.
Thank you, Your Honors.
Thank you, Judge.
Moelis and Company versus Auckland Financial.
Good afternoon, Your Honors. My name is Allison Schoenthal for the defendant Appellant Auckland Financial Corp. I respectfully request that William J. be permitted to participate in the appeal. He has been admitted pro hoc by this court. He's filed a notice of appearance for the oral argument, along with this court's letter previously granting him pro hoc admission. Thank you.
Thank you. Your application is granted.
Thank you very much, Your Honor. William J. On behalf of the appellant. The trial court here did not apply the contract's definition of a sale transaction. So for there to have been a sale transaction and summary judgment awarding the $3 million sum here, there had to have been a sale transaction during the tail period, and all of the consideration in that transaction had to have been for the sale of, quote, specified discrete assets.
And that's what triggers the entitlement to a fee. A sale transaction fee, correct? A
sale transaction fee, that's exactly right.
Okay.
And what the trial court equated that with here was the exchange of value.
So why wasn't there specified discrete assets based on new residential acquiring beneficial ownership of the mortgage servicing rights and legal ownership of the mortgage servicing rights? Why isn't that specified discrete assets, and why didn't it acquire that as part of the transaction?
It didn't acquire that as part of the transaction for consideration because that purchase had already been effected in 2012 and 2013 as part of the original transaction. All
but
the consideration
give less, didn't in fact pay, or both the parties pay substantial amounts of money to Oswin to forego getting its subservicing fees in the way that it was before, which was consideration. Clearly, it was a lot of consideration.
But respectfully, Your Honor, those are two different things. So your first question was about the transfer of the beneficial ownership. All the consideration for that, which was going to be automatic under the previous 2012-2013 agreements, under Section 2.3 of the prior sales supplement, all the consideration for both what was transferred in 2012 and what was to be transferred later, all the consideration is paid back in that first period. Now, your second question was about the money that's paid to Ocwen in this transaction for giving up some of its future subservicing compensation. That's certainly right, but there's no transfer, there's no acquisition by New Residential of any subservicing rights. It's just paying less in the future. Justice Friedman,
does a change involving millions of dollars in that 2017 agreement as to how Ocwen's going to be paid? Before, in the 2012-2013, there was going to be a payout. As you subservice, there was a fee paid to Ocwen. But when you get to 2017, you're giving up that payment coming as you're doing subservicing, and you're getting a lump sum payment. Isn't that what happened? And isn't that a significant change in how Ocwen was going to be compensated? And isn't it fair to conclude that the way these agreements had been structured, Moelis would be entitled to a fee for that?
I don't think so, Your Honor, for three reasons. So first is that the definition of sale transaction doesn't include every large exchange of value. It has to be a specified discrete asset. Second, Ocwen did not give up any subservicing.
But what could be more of a discrete asset than being in a situation where you're waiting to get paid as you're doing work, and instead you're getting a lump sum payment up front? That's not a discrete change in a discrete. That's not the acquisition of a discrete asset.
Well, recall, Your Honor, it's not whether Ocwen acquired a discrete asset. It's whether someone else, an acquirer, acquires a discrete asset, a specified discrete asset. So in this case, New Residential doesn't acquire any subservicing rights. Ocwen remains the subservicer of every.
Well, doesn't New Residential acquire that it's no longer, for whatever its economic reasons were, it's no longer in a position of having to pay out piecemeal, and instead it's making one lump sum payment? Isn't that an acquisition?
It's not an acquisition. I think that really gets to the heart of the question, Your Honor. That's not an acquisition because it's not gaining an asset. At most, it is mitigating some future liability, but it is not. It's not gaining an asset.
Also, under the 2012-2013 agreements, when was this right that Ocwen had to doing subservicing? When was that going to expire? Didn't that have a 6-year limitation on it?
It had a 6-year limitation running from the closing date. So, and each supplement. And
wasn't the result of the 2017 agreement to extend that for many years? Is it perhaps till 2027?
Yes, Ocwen got a longer term as subservicer. That's correct.
And you don't think these changes are within the contemplation of the letter agreement that was made with Moelis?
We don't, because New Residential doesn't acquire a specified discrete asset. All that it acquires is the servicing rights that its predecessor had already paid for in 2012 and 2013. And the trial court did not find otherwise. Instead, because it didn't apply this specific definition.
I'm sorry, I'll let you finish that thought.
Sorry, I was just going to spend 30 seconds on the fee shifting provision, which just to say that there too, the trial court got the presumption wrong. The presumption about first party fee shifting in an agreement is not, well, you could have specified that you didn't want fee shifting. It's the reverse. It has to be unmistakably clear. And here there are at least three aspects of the agreement that don't fit with the idea that there's first party fee shifting. I'm aware that I'm over my time and I won't tax the court's patience. But really, as in the Hooper case, the existence of provisions like these, which are inconsistent with the idea that the indemnified party is going to be seeking indemnification for suing their counterparty. That's a reason why this is not unmistakably clear in favor of fee shifting, and that's why that too should be reversed.
Thank you, Mr. J.
Thank you, Your Honor.
Let me hear from respondent.
Thank you, Your Honors. Deanna Davidian for Moelis. The Supreme Court's ruling that Ocwen breached the parties' agreement should be affirmed. The Supreme Court correctly concluded that the 2017 transaction was a sale transaction. There's no dispute that prior to the 2017 transaction, Ocwen had the right to subservice mortgages and be paid fees on an ongoing basis over time for doing so. In 2017, Ocwen sold these subservicing rights and future cash flows to New Residential for $334 million. Ocwen and New Residential admitted in the 2017 transaction documents that a sale occurred. The 2017 transaction documents define Ocwen as the seller and New Residential as the purchaser. Pursuant to Section 2.01 of the 2017 transfer agreement, Ocwen sold subservicing rights and future cash flows to New Residential. Ocwen and New Residential repeatedly represented to the market that the 2017 transaction was a new arrangement whereby Ocwen sold subservicing rights and future cash flows to New Residential for $334 million. And we refer this court to our opposition brief at page 15, which highlights some of these admissions. And in particular, I'd like to refer this court to the parties' joint statement of undisputed facts, paragraphs 37 and 38, which is A836 of the record, whereas the parties agree that Ocwen's audited financial statements refer to the $334 million that they received in connection with the 2017 transaction as, quote, proceeds from sale of mortgage servicing rights. Ocwen admits at page 14 of its reply brief that, quote, the 2017 transaction involved Ocwen's sale of future cash flows. Therefore, a sale transaction indisputably occurred here. Ocwen argues that the 2017 transaction was an amendment of a prior agreement and that the $334 million that it received was the net present value of subservicing fees it would have received over several payments in the future under the prior agreements, but an amendment can still effectuate a sale, and a sale between sophisticated parties almost always involves the exchange of things that are approximately equal in present value. Again, the relevant inquiry here is whether New Residential acquired specified discrete assets from Ocwen, and it unquestionably did in connection with the 2017 transaction. And for all these reasons, the Supreme Court's ruling that Moelis is entitled to a sale transaction fee of approximately $2.3 million should be affirmed. The Supreme Court's ruling on attorney's fees also should be affirmed. Moelis has a right to recover attorney's fees if two requirements are met. First, Moelis must be involved in any capacity and any action arising out of or related to this agreement or any matter referred to herein. This requirement is clearly met here because
your position is any action to enforce the Moelis agreement should be sufficient. That's your third course of action, is it not?
Correct, Your Honor. Okay. Moelis here is enforcing this agreement, and therefore it's unmistakably clear that Moelis is entitled to recover its attorney's fees under the plain language of the contract. And as Justice Maisley noted in her decision, these are sophisticated parties. They're represented by counsel. If they wanted to limit Moelis's right to attorney's fees in the way that Ocwen suggests, they could have done so by including that type of language in the contract, but they didn't. And therefore, the Supreme Court's ruling that Moelis is entitled to recover its attorney's fees also should be affirmed.
Thank you.
Thank you, Your Honor. And specifically on attorney's fees, we would refer this court to the Rothberg case, which is in our opposition, page 39, as well as Sagen Advisors versus ANF, index number 652288, 2015, which is out of the New York Supreme Court. There, Justice Raycower looked at a virtually identical attorney's fees provision in an agreement between an investment bank and its client, and Justice Raycower granted summary judgment to the investment bank on its claim for attorney's fees in an action between the contracting parties to enforce the agreement.
Thank you, counsel.
Thank you. If your honors have no further questions, we would respectfully request that this court affirm the decision of Justice Maisley. Thank you so much.
Thank you. Mr. J, you get 1 minute rebuttal.
Thank you, Your Honor. I'll just try to make a couple of quick points. First, my adversary said that Ocwen sold subservicing rights. That's just simply not correct. Under the transaction, Ocwen continued to subservice the same mortgages that it was subservicing before the transaction. It did not sell subservicing rights to a third party, and it certainly didn't sell them to New Residential, which did not become a subservicer. That might have been a transaction that could entitle them to a sale
Didn't
transaction.
it sell mortgage servicing rights, though, even if it didn't sell subservicing rights?
The servicing rights were transferred. This goes back to my answer to your prior question, Your Honor. They were transferred pursuant to what had always been the party's intent when the consideration was exchanged in 2012 and 2013 for the servicing rights. So the beneficial ownership did transfer, but for no consideration. And that really is the key point.
If the transfer already occurred, why were they getting all this consideration?
The consideration is for the restructuring of cash flows, and this a sale of cash flows or an agreement to restructure cash flows. That's not within the definition.
Could this transaction ever have taken place if they had not agreed to give up ownership rights to the servicing rights? Could this transaction then have occurred in the way it occurred? Wasn't there consent required?
No further action was required to give up the beneficial ownership. That's expressed in the original documents that no further action of any person is required once the once the servicing transfer date occurs. Finally, on the attorney's fees, very quickly, my adversary said that the parties could have provided otherwise because they're sophisticated. That gets the law exactly backwards. The presumption is the other way. And just to respond to the point about in any capacity, we submit that that's naturally read, that if Moelis is involved as a party or as a witness or as just a person that's being injured, it could seek indemnity. But that doesn't mean that it's involved as a plaintiff. And that you can see that from the rest of the language, which refers to being involved in an action but not bringing one.
Thank you. Thank you both.
Thank you.
Public Administrator of Queens County. I'm sorry. I misspoke. It's Brown versus Sureguard Storage.
Good afternoon. May it please the court. My name is Marcelo Buitrago, and I represent the plaintiff, Audley Brown. Hope everybody's doing well. We're seeking to reverse a decision that was entered and granted, given the fact that we believe that there were mistakes in the application of law. We believe that the defendant clearly was not an out-of-possession landlord. And as Judge Weber pointed out before, we need to really look at the lease in the prior case. If you look at the lease in this case and the case law supporting this, it specifically says that a landlord is supposed to relinquish, quote, absolute control. And if you actually look at the lease agreement, paragraph 13, under section 13, it specifically reads, no alterations or additions were permitted to be made without first obtaining consent from public storage. Quote,
Counsel, are you trying to argue that means it's not an out-of-possession landlord?
Yes.
It right to make structural repairs, it's not an out-of-possession landlord? Is that your argument?
Your Honor, my argument is that, I'm so sorry. My argument is the fact that simply because they're not in possession, does that mean they're not a possession landlord? Contractually, they reserve the right to maintain the property.
Well, they only, I thought the precedent in this department on very similar clauses is that the landlord gets the right to re-enter, assuming that there's structural defects that are found. Right. I thought the evidence was undisputed that this incident, was caused by more improper, not by improper drainage, but by natural accumulation and precipitation. In fact, the expert testified about or opined that the slope was 2 to 5% of the parking lot, so there was no structural defect.
Well, Your Honor, that's actually the point. There's a plethora of issues of fact regarding the structural defect. What you're quoting is the defendant's expert, which again, our expert was precluded from testifying in opposition by the court because saying that there was no CV.
How did you create an issue of fact? The defendant's expert went down to the premises, did measurements, and says there's a 2 to 5% drainage slope from front to back, and that's an appropriate way of having the surface of the parking lot. Your expert didn't even go down. He's making these determinations based on photos. He is making slope determinations based on a photo.
Sure, Your Honor. So it's the determinations are based on the fact that the property was changed based on the photographs. And if I may add, at one point, which I argued during the oral arguments, their initial motion, I had requested permission to have my expert go to the location to do a site inspection himself. That being said, the expert, Mr. Simon, testified that pursuant to the Google Maps and the difference in pictures that were taken, which is admissible, and the court does take judicial notice of the photographs, it shows that the parking lot had been paved at different times, which supports the argument that once it is paved, it has to meet the codes and the rules and regulations that are applicable at that time. Therefore,
but counsel,
the defendant's
expert took the slope measurements. Wasn't that, I mean, picture or no picture, took the slope measurements at the time or shortly thereafter the incident happened.
It was actually,
no matter whether you have photographs, whether your expert has photographs or not, the defendant's expert took the slope measurements soon after the actual accident.
If I'm not mistaken, it was actually years after. It wasn't shortly after that they took the measurements, Your Honor. So the measurements that the defendant's expert took was actually following those Google sightings and the Google measurements and the depictions that were different in the work that was being done. So I actually disagree.
But the defendant presents a microtypographical survey, and you present an expert who renders an opinion based upon photos as to what the topography is.
Your Honor, my expert renders his opinion based on the photographs and his expertise and cites sections and codes. Now, Your Honor, just so we're clear at this point, we believe that there's issues of fact based on these two distinguishing testimony by the two experts. My expert specifically cited codes and sections that applied that show that the defendant was lying.
Were those code provisions even applicable?
They were, Your Honor. They are, and the expert submits that. And to be clear, this wasn't before the court because the judge disqualified the expert because there was no CV attached. And then in defendant's papers on page 64,
those provisions are applicable to the slope condition?
Those sections are applicable to the way the drainage system is to be maintained. If I may say, I'm not sure who's beeping. Oh, I'm sorry. If I may say one more thing regarding the defendant's argument that there was no explanation for the CV missing, within page 64 of their argument, they say that plaintiff's counsel should have submitted an affidavit with somebody with personal knowledge or somebody supporting the argument why the CV was not there and why the CV and the expert's opinion should not have been considered. If you look at page 1355 of the record, it is actually the affirmation of Mr. Simon where he confirms and he states, yes, as an oversight of my office, we did not submit the CV. It is unjust for the client to be prohibited and be penalized for that, Your Honor.
So let's admit that was error. Was he still going to issue his opinion based on the photographs? I mean, I don't understand how, expert or otherwise,
sure,
how looking at photos you're able to determine the slope.
Sure, Your Honor, if you look at
measurements.
The photo, remember, the case is not only about the slope. The case is about the fact that the parking lot was not maintained with a proper drainage system. And the slope measurements that the defendants took, if you look at it, if it's a slope that it should have been this way, and remember, there's testimony that there were puddles by defendants' own witnesses, by Vertical's witnesses, that state that the ground was not even, that there was no slope, that there were puddles. So their own expert is contradicting the evidence, testimony, which is an evidence of other witnesses. So ignore, if you even disqualify my expert, Your Honors, the testimony by the witnesses who testified at depositions completely contradict the findings of the expert. That is an issue of fact.
Thank you, counsel.
May I proceed, Your Honor?
Yes, you may.
Joseph Miller for the defendants, respondents, appellants, public storage and SureGuard. For sake of convenience, I'll refer to them both as public storage if you'll permit. The lower court correctly held that public storage is entitled to summary judgment. As Your Honors have pointed out, the expert conducted an extensive—
Would you address whether the administrative code provisions which the plaintiff points to are applicable here?
Judge, none of the administrative code provisions are applicable. I'll go through them one by one if you'd like. 27-479 is not applicable because the lot itself was finished with asphalt, so it satisfies the code. 27-901 refers to having potable water. They're not required to have potable water because it's an unimproved lot. 30-02, which is the big one that their expert tries to refer to, is the grade. As my expert put in two separate affidavits, one the initial affidavit and the supplemental affidavit, he did his study. The water does come down at a grade, and then it goes, if you're looking at the lot, it goes to the left and goes into a pervious surface space, which is how it's supposed to be by the code. The two other ones—
doesn't that specific code to, refer to runoff onto the sidewalk, and there was no evidence of runoff onto the sidewalk with this?
Correct. That was, yes, Your Honor. That was what my expert was trying to say was it doesn't run off to the sidewalk because it goes down and then it curves, depending where you're standing, it then curves either right or left into pervious surface.
Because actually the pictures in the record show the lot full of snow, but the sidewalk is clean.
Well, Judge, I'm going to get to that in 2 seconds, if you will. Now, with respect, I think what you're referring to, Judge, more importantly, I'm sorry, Judge Friedman, is 27-481B, RS16, P102, and 27-901, which are alleged by their expert, and they do not apply to this case because those statutes are not to be applied retroactively. This lot was when we purchased, or when SureGuard 10, which was the initial owner, purchased it, was back in 1986. These codes were put into effect afterwards. They're not retroactive. They don't.
Wasn't it 88 or 80, maybe 90?
Well, it depends. Well, the SureGuard
code provisions came into effect afterwards. I think, wasn't it 1990?
Well, SureGuard 10, which is a different entity, purchased it on December 4, 1986. On March 1, 1994, it was transferred to SureGuard Storage Centers Incorporated, which is the person named here. So both of these, this was done back in 1986 and 1996. Sorry, two different codes. Neither one would apply retroactively. I mean, it's as simple if I buy a house in 2025 and it's not up to code right now, but it was up to code when it was built. I don't have to redo the entire house to bring it up to code. That's just the basic law. Now, Judge, there is a common sense approach here. Everybody concedes that there was snowfall in the days preceding the accident. The vertical, who controls and maintains the lot, concedes they did not shovel the snow. Their two experts have said this condition that they claim is a result of not shoveling the snow. It has nothing to do with the drainage. If you look at the photographs in the record, there's two specific ones, and I believe you're referring to the one I'm talking about. You will see that the sidewalk is shoveled, the parking lot is not shoveled. So it's easy. It's a
parking lot's full of snow.
Parking lot's full of snow. So if you just took a shovel and shoveled the parking lot, it's going to look like the sidewalk. There's going to be no snow. This is not a drainage issue. This is somebody decided they weren't going to shovel the snow, and it's actually a point conceded by vertical. So it's not even an issue as to whether or not it was removed. This has nothing to do with a drainage issue. My client was an out-of-possession landlord, and they had not control. Thank you, Judge.
Thank you, Mr. Miller. Okay, let me hear from respondent.
Thank you, Your Honor. So one thing I'd like to point out and mention before, the court had said that the inspection by the defendant's experts conducted shortly after. Again, it supports my argument before. Their inspection was actually done on June 7th, 2019.
So I think I made that. I think
4
I made
years
that
later.
error. So let's. Okay. So
okay, no, I just wanted to point that out, Your Honor. So regarding the actual, the expert Simon testified that there are issues of fact regarding the paving, and once the pavement was changed, there are certain requirements that were needed. Defendants did not comply with those. Okay, and those are just facts. I understand that they purchased the property later on, but once they began to make a change, a modification to the property, which is confirmed through the Google photographs, they were supposed to meet the standards. And again, none of this.
So when was the lot repaid?
How this is all okay.
I'm sorry. None of this
When
goes
was the
around
lot
the fact.
repaid? You pointed that they made changes. What year was that in?
What year? I'm sorry, Your Honor.
Yes.
I believe it was 2013, if I'm not mistaken. So,
I still don't understand how the expert, I don't believe he details how he can conclude from the photograph that there have been changes that have indeed affected the grade, especially, and how that's relevant here, where the parking lot, as has been agreed, I think, is filled with snow.
Right, Your Honor. So the most important thing is the issues of fact, and that's what we have to focus on. There's issues of fact given that Mr. Audley Brown specifically told a manager, an executive of the defendant that there were issues with the drain and that there were issues with the slope. Specifically told him that. So there's an issue of fact. Whether the defendant put in a lot of affidavits from other people saying there's no executive that looks like that. But the reality is that's an issue of fact. Whether in fact Mr. Brown told a supervisor, an agent of the defendant, that the slope was improper and that there was accumulation of water because of the slope.
Didn't you also say, didn't the person, even by plaintiff's version, didn't that person also say he's not the one to tell? Because they didn't control this.
That's not what he said, Your Honor. He didn't say I'm not the one that controls this. He simply said he just took the information.
He said he's not the one, right?
I don't believe that was what he said, Your Honor, but I believe he simply said he took the information and he said he would.
I'm not going to tell you I remember his precise words right now, but he conveyed one way or another. He wasn't the one you tell.
But it doesn't change the fact that he's an agent and he was informed. And not only that, the tenant from Vertical confirmed. The tenant confirmed that the parking lot was not sloped and that it was flat and that it created puddles and that it didn't have proper drainage system. Again,
okay.
That's
Thank
Vertical.
you, counsel.
Thank you.
Thank you, counsel. Thank you both. Public Administrator of Queens.
Judge, I'm sorry. I think there's another party in my case that hasn't spoken yet.
Oh, I thought Vertical got 5 minutes, but they allowed the appellant to rebut without them getting their 5 minutes in. I thought you were not showing up, so
I don't know.
I'm sorry for that assumption. The appellant already went, right? I'll give you I'll give you a few minutes. Go ahead.
But it's Vertical has to go, Judge. I went.
Go ahead. Yeah, Vertical gets 5 minutes. Who's representing Vertical? Mr. Miller, am I missing somebody that I don't see?
Yes, there was somebody who checked in for Vertical. I'm not sure if they're still here, though.
Right, and they were supposed to go after you went.
Correct.
Right, but instead they allow Mr. Butrago to rebut your argument. I just assumed that they were not in.
No, I think it might have just been an error that Mr. Butrago went before they went.
I wasn't sure if you wanted me to, when you asked me if I wanted to oppose or make a statement regarding their argument, Your Honor. That's why I followed suit.
Is there anybody here representing Vertical?
This is the attorney that we called earlier. Ms. Rojas couldn't get a hold of him, and I actually called him and let him know. And I also instructed him, per Mrs. Rojas, that he can call in instead if he can't get a video through. Right. And he said okay, and that's kind of what we left it off.
I mean, he's not on video or on the phone, so I just gonna go ahead and proceed and mark him submitted.
Thank you, Judge.
Okay, thank you both. I don't know if that's him. Let me admit him. That individual that was just admitted, is he the attorney for Vertical on Brown versus Sugar Storage? I don't think so. Okay. You only get 3 strikes, right? So thank you both. Counsel, next case on the calendar is Public Administrator.
May it please the court, Brian Forbes with Baxter, Smith and Shapiro on behalf of third-party defendant, appellant, respondent, Cashier Maintenance and Management. To start off in this case, I think the Supreme Court got the most important fact right, but then misapplied the law to that fact. The most important fact in this case, as the Supreme Court noted in its decision, was that the plaintiff's accident was unwitnessed by any living person. The cause of the accident is unknown and will never be known. This is a case where the plaintiff was found at the bottom of a fixed ladder, both to the ceiling and the floor, and no witnesses were had to the accident. No witnesses have ever been located. On that basis, it has been our position that Labor Law 240 does not apply to this case.
Counsel, let me ask you about the indemnification issue in the case. Why isn't Ridge, 124 Ridge, entitled to contractual indemnification against you? Because according to the indemnification, which appears on page 329 of the record, the liability of Casur Heronder is absolute and is not dependent on any question of negligence on its part or on the part of its agents, servants, or employees. And it starts off by saying Casur shall be solely responsible for physical injuries to persons occurring, and shall does hereby indemnify and save harmless the 124 Ridge from liability and any and all claims for damages. So why isn't 124 Ridge entitled to actually summary judgment against you, if you will, on the indemnification issue, even if the plaintiff loses on the case, even if the case against plaintiff is dismissed? Aren't you in for attorney's fees and other expenses that have been incurred under that very broad indemnification provision?
Well, that's a great question, Your Honor, but that indemnification provision, and let me just clarify, I believe you're talking about the single-page rider that was signed on the 26th of March in 2016. Remember, this is a 2014 accident, so right. It was signed a year and a half.
Signed post-date to the accident.
So the rider doesn't have any language in it that it has a retroactive effect. And
it'd be an issue of fact. It'd be an issue of fact whether that rider is meant to cover the pre-happened accident.
I would posit that the rider, there's no question of fact. It doesn't state that it's predated. There's nothing in there that states that it's retroactive. However, there is an indemnity provision that's been argued to be in the AIA contract, which was also signed after the accident. That was signed about 7 days before or 6 days before the rider. That indemnity provision requires a showing of negligence to trigger on behalf of Cashier Maintenance. Obviously, as no one has been able to identify the cause of the accident, and there's nothing but pure speculation as to what the cause might be.
So I understand that you say it doesn't apply, but one could argue that there is an issue of fact whether or not this indemnification provision, which does not require negligence, should apply to this accident which happened before it was executed. I mean, maybe the parties were conducting themselves as if this was, and that would be the issue of fact, is that this was going to govern their relationship. I know that's not your position, but one could make that.
And I understand what you're asking, Your Honor, and I think part of my concern with that is that the testimony discussed the AIA contract and whether that was governing the relationship of the parties because it actually described the work that they were doing, whereas the rider doesn't describe the actual work that they were doing. It's just a rider that was signed years after the accident. So, and there's no retroactive language in it, and there's no date in it that would indicate that it would apply to that project or that contract, because you have to remember Cashier Maintenance also has other jobs, I believe, with 124 Ridge. So to the extent that there's a question of fact, I would posit that would be on 124 Ridge to present some admissible evidence that there should be a retroactive application of that. And I don't believe that there's anything in this record with the note of issue filed that would indicate a retroactive intent between the parties as to the rider. As to the AIA contract, I would argue that that's a different ballgame, but the language thereof is different and requires negligence, which cannot be satisfied.
Thank you, Mr. Forbes.
Would you like me to address the 240 or 241.6 any further, Your Honor?
Well, your time expired, so, you know, I usually leave it up to you to chart the course of your argument. So you're going to have 1 minute in rebuttal, so you may want to address it then.
All right, thank you, Your Honor.
Your Honor, I'm sorry, I'm just not sure if I go next. I'm defendant, third-party plaintiff, respondent, appellant.
You 124, Rich?
Yes.
Yeah, you're next.
Good afternoon. May it please the court. My name is James Rowland, and I represent the defendant, third-party plaintiff, 124 Ridge in this matter. Just quickly, there's no dispute. The evidence is clear that we did not supervise and control the work that was being done. Mr. O'Sullivan, I'm sorry, admitted that he was responsible for the site safety, CASOR, and that CASOR was responsible for supervising and controlling the workers at work. So the only liability that we'd possibly have here is vicarious liability. In the underlying decision, the court did get it right. We defendants met their burden in seeking to dismiss the 240 and 241.6 claims. The evidence, counsel argues that it was post-accident, but the evidence, the only testimony is that the ladder was secured at the top and the bottom. The photographs show that the ladder was secured at the top and the bottom. And OSHA, when they investigated it, never reported anything about any unsafe condition with the ladder. Now, counsel for plaintiff in his papers 11 times uses either uncontroverted or incontrovertible when saying that the ladder wasn't secured. And there's simply no evidence to that. This was an unwitnessed accident. No one knows why the decedent fell off the ladder. The testimony and evidence that was submitted established that the ladder was secured when it was inspected. We met our burden, and the only thing that plaintiff's counsel could do in opposition to that was say that, well, we don't know when it was secured. How do we know they didn't secure it right after the accident? Why should we believe Mr. O'Sullivan? There's no testimony to refute his testimony, but we shouldn't believe him. It's the pure speculation that shouldn't be allowed.
Well, he has no personal knowledge, right? Mr. O'Sullivan did not visit the work site on the date of the accident.
No, he did, Your Honor. He did. He visited it about 2 hours after the accident, I believe, was the testimony. So he was certainly there the day of the accident. He wasn't there at the time of the accident. This ladder
went through from one floor to the next, right? I don't know if it went through the beams, but where a staircase used to have been, but it was leaning against what would have been the floor above.
Correct, and the photographs show a metal arm coming out from the beam, securing the ladder on the top. And the testimony was that it was secured on the bottom as well, Your Honor.
Okay, thank you, Mr. Rowland.
I'm sorry, is my time up?
Pretty much. I'll give you 30 seconds.
I'll save it for rebuttal on the issue between myself and CASOR.
Okay. Okay. Third-party defendant, CASOR.
I think
Your Honor, I went first.
Usually I don't have to intervene as to who the batting order. So is CASOR?
CASOR went first, Your Honor. I was first on the issue, and because I'm the appellant, so it should be plaintiff. Is that turn?
Okay.
Good afternoon,
Go ahead, Mr.
Your
Shaw.
Honors. May it please the court, John Shaw for plaintiff, responded appellant. At a minimum, the defendants did not sustain their initial burden of proof, putting aside that it is our position that because this is a death case and they're relying on Mr. O'Sullivan, who they claim in their papers gave unequivocal testimony of the noseworthy standard would apply.
But does noseworthy apply where both sides are in the same situation? I know you're saying that Mr. O'Sullivan knew what happened, but Mr. O'Sullivan was not present at the time of the accident. So both sides are in the same situation of not being in a position to say what happened. Does noseworthy apply in that circumstance?
It does, Your Honor, because defendants are relying on Mr. O'Sullivan's testimony. They claim it's unequivocal testimony
to show that this ladder was secured at the time. And because of that, noseworthy would apply, but hypothetically,
do we know what the cause of the accident is? Isn't that the key?
There is clearly my client fell from this ladder. Mr. O'Sullivan even testified that he was told by the coworker that there was a big thump, and the coworker saw my client or the decedent right on the floor next to the ladder. Mr. O'Sullivan.
But couldn't that be the result of a misstep? Having nothing to do with the ladder?
Well, first of all, they have the burden of proof to show that the ladder was secured and my client simply lost his balance. They have not proven that at all.
The fact remains that Kasur, 124 Ridge, and the plaintiff are all in the same boat as to how this accident happened. There is no witness who can testify. You're talking about witnesses who arrived subsequently, and in case of Mr. O'Sullivan, 2 hours later. He's not in a position to say how the accident happened.
This was I think Your Honor even pointed out, the ladder was the only access to the second floor. It was the only means of access because Mr. O'Sullivan even admitted that the stairway was gutted. And there's case law when you have an affixed ladder, which we don't even know if it was secured because Mr. O'Sullivan came 2 hours later or more. He was notified of the accident actually 2 hours after the accident, but Mr. O'Sullivan admitted there were no lifelines to protect the worker. No one was holding or supporting the ladder, and there were no lifelines. And the only means of access was this ladder to the second floor. And there's no dispute that he did fall from this ladder. OSHA came on site, and that's another thing. They rely on the testimony of Mr. O'Sullivan to say that the ladder was secured, but also his credibility is at issue. OSHA said that he was evasive. He denied that my client even was working for.
Do we know whether the photos were taken during the OSHA investigation?
They were allegedly taken at the OSHA investigation, but OSHA came 2 days later because Mr. O'Sullivan violated OSHA, which he was assessed.
Well, that's because Mr. O'Sullivan did the report 2 days later.
2 days later, we don't even know if that was the ladder at the time because he violated the OSHA requirement because he didn't want to acknowledge. But the bottom line, Your Honor, is that there's no question my client fell from a ladder that was the only means of access to the next floor because they gutted the stairwell. And there's case law under Spiteri that you don't even have to show. So it's respectfully submitted that they didn't sustain it. And at the minimum, there's a question of fact here, and which is based on Mr. O'Sullivan's credibility.
Thank you, Mr. Shaw.
Thank you, Your Honor.
Okay, Mr. Forbes.
Thank you. I want to get through three quick points here, especially the burden. Plaintiff has talked about we didn't meet our burden. There's a number of cases that deal with a defendant showing their burden on a motion for summary judgment by showing conclusively that a plaintiff cannot present anything to a jury as to causation other than pure speculation. I think we can all agree in this case we do not have any inference as to causation from the testimony, from the admissible evidence, and the note of issue has been filed. This matter has been certified ready for trial by the plaintiff. On the second point, we've talked here about noseworthy and we've talked about OSHA. I want to point out that the plaintiff does not have a cause of action against Cashier Maintenance. He is suing 124 Ridge, and he is claiming that the noseworthy doctrine applies to them. They are in no better position than the plaintiff. They were not on the job that day. The noseworthy doctrine cannot apply to a claim against them because they are the direct defendant and they are the party who was not present at all during the course of a majority of the work and at least on the day of the accident, as well as that the OSHA standards that plaintiff is claiming Casual Maintenance violated are not OSHA standards applicable to a non-employer such as 124 Ridge, who he's suing. I will also point out that to the extent plaintiff claims that the delay in Mr. O'Sullivan notifying OSHA affects his credibility, there's no dispute that the police and the ambulance were called immediately after this accident, and that the Department of Health was investigating from day one, minute one. So any inference that he loses credibility by inadvertently delaying and notifying OSHA is essentially preposterous when the authorities were on site immediately. The last point I want to make, and this is in response to Justice Friedman here, the direct defendant, 124 Ridge, never moved for summary judgment at the underlying court against Casual Maintenance on their indemnity causes of action. So I know you would ask if they would be entitled to summary judgment.
You know, I think, you know, they wouldn't necessarily have to for them to get their relief. But what in your favor is the fact that they have prosecuted this appeal on the ground of seeking to hold you on the failure to procure insurance. They've sort of limited their claim. I think that's the way I read their brief, that their interest is to hold you for having failed to procure insurance, protecting them.
Well, and I would refer to my arguments in my brief on that point. There's no dispute that the contracts were both signed 1.5 years after the accident. You can't procure insurance naming someone else after the fact. If you could, no one would pay their premiums up front and they'd go procure insurance after the accident. It's impossible. So to the extent that there's an agreement that says we would have to retroactively procure insurance, it's not possible to exist. So that's going to be problematic, I think. So I don't believe that 124 Ridge moved for, I know they didn't move for such relief before the trial court. To the fact that they're relying on an opposition, I think impossibility comes into play. Is there any further questions, Your Honor?
We got your point. No, thank you, Mr. Ford.
Thank you.
Can you get 1 minute, Mr. Rowland?
Thank you. Just very quickly on my cross claims, my third party claims against Kasor. The contract was actually dated December 30th of 2014, I believe is the exact date. It was signed by Mr. Sullivan after the accident, but he testified that that was the contract that he did all his work under and that Kasor worked under. In connection with the home.
So it'd be an issue of fact whether that contract was meant to cover the relationship.
And that's why I did not move for summary judgment, Your Honor. And as far as the hold harmless agreement goes, Mr. O'Sullivan testified that he couldn't recall when he signed it, but he did recall my client specifically going to him in connection with this accident and saying, you need to hold me harmless and indemnify me for this. And then an agreement was signed. So he testified that this was the impetus of this case. This accident was the impetus of that document. And
your brief seems to be directed more towards the issue of failure to procure insurance.
I included all 4 of my causes of reaction, Your Honor. I don't favor one over the other. I think I'm right on all of them. And then in connection with the plaintiff's arguments, the cases that deal with with these fixed ladders were all external ladders, such as attached to water towers, external walls, where there was supposed to be some other type of safety device. There's been no evidence anywhere, no case law, no expert that said a lifeline needed to be used or employed for this gentleman to go from the 2nd floor to the 1st floor here. So I don't believe those cases are applicable. And then lastly, as far as the burden, the courts have been clear in Blake and Narducci that the fact that an accident happened isn't enough. There has to be evidence of a violation. And in connection with the ladder, there has to be evidence that a ladder was defective or inadequately secured. And there's simply no evidence in this case that occurred here. So the Labor Law 240 and 241-6 claims, which are based on the fact that the ladder, if it wasn't secured, needed to be held, should have been dismissed.
Thank you very much. Thank you, all 3 of you.
Your Honor, do I get my 1 minute of rebuttal?
You are an appellant as well, so I thought you were going to waive that if we were lucky, but go ahead.
Thank you, Your Honor. First of all, with respect to an expert, there's no requirement that a party has to produce an expert for purposes of summary judgment. There are hundreds, if not thousands, of cases. Again, whether or not this was an external ladder as opposed to an internal makes no difference. This was an access ladder, and it was the only means to get to the second floor. They gutted it, and Mr. O'Sullivan conceded there were no lifelines, which clearly were necessary to protect my client. And it clearly goes within the realm of an access ladder. And again, there was no evidence that that ladder was secured. That certainly, that's a question of fact. Under the Krejbich case, someone comes immediately after. Mr. O'Sullivan comes 2 hours plus later saying, oh, it appears to be secured. But that is speculation on his part. My client falls from a ladder. There were no lifelines, and it was only his only means of access.
We got the argument, Mr. Shaw. Thank you. Thank you all.
Thank you.
Thank you, Your Honors.
Marker Finance.
Good afternoon, Your Honors. May it please the court, Evan Weintraub on behalf of Defendant Appellant Middlegate Securities. We are respectfully requesting reversal of the lower court's decision, which denied Middlegate's motion to dismiss the complaint. Your Honors, this case involves claims by 2 entities and 5 individuals that assert that in 2006, they deposited funds into a Swiss bank account at the request of Mayor Sutton and Isaac Sutton, who advised them to transfer their funds there. The claim is that subsequently the funds were depleted and that they were unable to obtain those monies. The complaint asserts 6 causes of action. However, as we stated in our briefs, none of those state a cognizable claim against Middlegate. Specifically, there is a claim for breach of contract against Middlegate Securities. However, there is no allegations in the complaint as to what parties were to that contract, how Middlegate was involved with the contract, when the plaintiffs do not admit that they ever had an account at Middlegate or transferred any funds to Middlegate. Their claim seems to be that Mayor and Isaac Sutton back in 2006 had some affiliation with Middlegate, and therefore there is a claim of apparent authority to drag Middlegate into this action.
This is a pleading motion. It's not a summary judgment. And there is an allegation that they did enter into an agreement with Middlegate, that there were actions by Middlegate, which was a breach, which included setting the forged authorization, forming Middlegate Israel, and it's a pleading motion. So why isn't it sufficient to state a cause of action based on the allegations?
Respectfully, Justice Kearns, the claim against Middlegate, or the claim of the contract here, is that the agreement was that the funds would be quote unquote conservatively managed. We have specifically cited case law in New York, Guild versus Hopkins, that type of language in the context of an investment is so vague that it has no meaning. Therefore, the plaintiff's claims that they
is not that their claim breach is not that it was not conservatively managed. They're alleging much more egregious actions to constitute the breach, not just that it was not conservative, but that there was actual theft, forgery, fraud, fake authorizations, manipulation of accounts. That's not just saying that there wasn't conservative investing.
Yeah, correct, Your Honor. However, what I was trying to explain was what was the understanding, what was the agreement. So, and with respect to your point, Judge, the claims with respect to the bad acts, which I'll refer to them, they're not specific to Middlegate. Yes, they submitted a fax.
Is there an allegation that in March 2011, Middlegate faxed a forged transfer authorization?
The allegation, yes, there is that allegation. However, as we cited in our papers, the fax footer is from an entity, Middlegate Insurance.
It's
not
affiliated with Middlegate, though. Why can't we give in the current posture? Why should we not give plaintiff an inference, a favorable inference?
Your Honor, as Mr. Sutton pointed out in his affidavit in opposition to, in support of the motion, that Middlegate Securities had no such affiliation at that time, that they had no involvement with these plaintiffs, and a singular fact.
And you want us to find that as a matter of law?
Right, you're going beyond, to add to what Justice Acosta said, this is a motion to dismiss. We have to accept the allegations as true. What you're submitting as evidence goes beyond appropriate material for a court to consider on a motion to dismiss.
Respectfully, Your Honor, we did not submit the facts. That was submitted was not referred to in the complaint.
I'm not talking about the facts. I'm talking about your arguments about these two companies are not affiliated and that the facts didn't really come from you. To determine that issue, we have to accept as true that the facts did come from your company. Your arguments as to why it didn't go beyond the four corners of what you're entitled to argue in a motion to dismiss. That was the point I was trying to make.
Understood, Your Honor. With respect to the tort claims that were asserted here by the plaintiffs, specifically breach of fiduciary duty, there is a specific allegation in the complaint that the breach was that the defendants did not obtain written authorization or signatory to effectuate any transfers. That allegation leads to the conclusion that these were not discretionary accounts. We cited case law, Seal versus Barclays, that where such written authorization is required, it is not a discretionary account, and therefore there is no fiduciary duty. Further, Your Honor,
aren't you denying the existence of a contract here?
Yes, we are, Your Honor. But and going to your point,
so you agree that the breach of fiduciary duty cannot be considered duplicative of the breach of contract claim, right?
Respectfully, Your Honor, I disagree. The case law provides that while they are allowed to assert claims in the alternative here, they have to support both claims with the elements, both claims, and here they have not done so. Again, there are so many conflicting and vague and ambiguous assertions in the complaint, as I just stated, that, for example, if they needed written authorization and signatory power to make any transactions, then there could not have been a fiduciary duty.
Okay, thank you, Mr. Weintraub. Okay, respondent.
Yes, may it please the court. My name is Edward DeLito. I'm with Storch Byrne LLP, attorneys for plaintiffs' respondents. Middlegate's primary argument here is that the complaint's allegations of wrongdoing by Mayor Sutton and Isaac Sutton are not allegations of wrongdoing by Middlegate. The fact is, however, that Mayor Sutton and Isaac Sutton are alleged to be founders of Middlegate. They're alleged to have had offices within Middlegate's offices and to have been running Middlegate and to have been doing business from Middlegate's offices. And the black letter law of New York is that a corporation is responsible for the acts of the authorized agents, even if particular acts were unauthorized. So at least for pleading purposes, when plaintiffs are giving $11 million of their money to Mayor Sutton to manage, and Mayor Sutton is notoriously a manager of Middlegate Securities, the contract is with Middlegate.
With respect to the breach of fiduciary duty, I mean, usually we don't find one with respect to a broker-customer relationship. Can you explain why we should in this case?
Yes, Your Honor. The case law and the judge and the Supreme Court held that there was a discretionary account and a fiduciary duty follows a discretionary trading account. This was, in fact, a discretionary trading account. What's happening is that we allege that the Atlas failed to verify the fraudulent signatures in taking instruction purportedly from plaintiffs. That doesn't make this a non-discretionary account. And in fact, there's evidence that Mayor Sutton was directing the investments through Atlas. Atlas has admitted that it took instructions from Mayor Sutton years after the money was funded, and he directed the money to Mayor Sutton's other companies and companies owned by Middlegate, such as Middlegate Israel. So I would also point out that even Middlegate admits that there is a fiduciary duty, a limited fiduciary duty, even in non-discretionary accounts. For example, a non-discretionary broker has a fiduciary duty to execute the trades that were directed. He has a fiduciary duty not to steal the money that he's entrusted with.
Why isn't the fiduciary duty claim time barred?
The fiduciary duty, because, Your Honor, it's Middlegate's burden to show when the claims accrued if they want to move on the basis of statute of limitations. We gave the money to Middlegate in 2006, and we know that Middlegate and Mayor Sutton was still managing that money in 2011 when the fraudulent fax was sent out, when Atlas admits that they were taking instructions from Middlegate, and in 2013, which is well within the statute of limitations, Mayor Sutton told the plaintiffs that the money was invested in exotic investments and he would be liquidating it for them, but it would take some time. And of course, that never happened.
But you didn't bring your action until 2015, right?
2015, Your Honor. Yes, sir.
So even if you count the facts as the basis for the breach, doesn't that, with a 3-year statute of limitation, wouldn't that be problematic?
No, Your Honor, the facts, I think, involve $2 million. And I actually believe those $2 million might have been recovered. The point being that
with
the money
was statute of limitations I'm talking about.
Yeah, but I'm saying the claim is not, this is a fraudulent act by Middlegate, but that's not necessarily the money we're seeking to recover. The fact is that the money was given to invest in 2006, and the evidence shows, at least a little bit we know, that it was dissipated over time. It wasn't dissipated in 2006 or 2011. We know that there was still money in 2013.
The last transaction.
I'm sorry, Your Honor.
What's the evidence of the last transaction? But what is the latest that could have accrued, according to you?
The evidence is that in 2013, Mayor Sutton still admitted having some of plaintiff's funds under his control, and that he promised to liquidate it and give it back to them, but never did in 2013. So we know that there was still money in Middlegate's hands in 2013. We just don't know when the particular money was dissipated. We know it's dissipated somewhere between 2006 and 2013, but there's no evidence as to actually when he stole the money.
Thank you, Mr. Dolido.
Thank you, Your Honor. Thank you to the court.
Your Honor, may I have 1 minute in the rebuttal?
You got 1 minute rebuttal.
Thank you, Your Honor. With respect to the statute of limitations argument, I just would like to point out that the complaint specifically asserts the monies were transferred in 2006. With respect to Middlegate, there are no other allegations after 2006 as to what, if anything, Middlegate did with the plaintiff's money. The lower court extended the statute of limitations period beyond the 6 years for the contract unjust enrichment and accounting and the 3 years for the breach of fiduciary duty and conversion based on its understanding that there was a fraud asserted here, but there is no such claim for fraud. The lower court also extended the statute of limitations based on a claim of continuous harm. But again, there were no specific acts alleged with respect to Middlegate after 2006. And finally, Your Honor, the plaintiffs on the motion argued for equitable estoppel, meaning that there was some action by Middlegate that was taken that prevented them from bringing the action earlier. As we pointed out in our briefs, it was the plaintiffs that brought the action in 2015 only after entering into a settlement agreement with Mayer and Isaac, having no mention of Middlegate, which we believe speaks volumes as to who the plaintiffs actually and believe, had anything to do with the loss of their money.
Thank you, Mr. Weintraub. Thank you both. Coylan versus KPP.
Good afternoon, Your Honor. May it please the court. My name is David Schwartz. I represent the plaintiff appellant. And my first and foremost goal here is to persuade this court to reverse the grant of summary judgment to the defendant owner and reverse the dismissal of plaintiff's labor law 240 and 241 causes of action. And that's not to say I'm waiving the claim that the lower court erred by not granting summary judgment to the plaintiff and not waiving my claim that the court erred in dismissing the case against Impact Group. The lower court made impermissible factual determinations, and it misapplied a statement made by the Court of Appeals in Narducci against Manhasset Bay Associates, which statement was modified and limited by the Court of Appeals in Utah v. City of New York and Quattrochi against FSCM Construction Corp. The determination that the fall of the sheetrock was not foreseeable, I think, was totally erroneous. First of all, my understanding of the law is that foreseeability is not an element of a 240 cause of action unless there's a collapse or failure of a permanent part of the building. That's exemplified in this court's case of Jones against 414 Equities, where someone is doing construction, walking on an ordinary floor, and the floor collapses. And the court said, well, if the floor had been rickety, if the floor had sagged, if the floor was rotten, and the floor was decayed, if there was something about this ordinary permanent part of the building floor that gave notice that the worker should have been supplied with a harness or a safety line or fall protection, then and only then would we consider a labor law 240 cause of action. But here, there was no evidence that the sheetrock, and there's a picture of sheetrock leaning against the wall on page 817 of the record, although we're not claiming that's a picture of the particular sheetrock that fell, because it was a whole pile of sheetrock that fell on the client. It was 2,100 pounds of sheetrock that fell on the client, according to my calculation. In any case, there was no, it seems to me that just from the affidavit of our expert, who talked about all the proper practices that weren't followed, which would, the fact that there exist proper practices, the fact that there exist clamps to hold items like this from falling over, the fact that there exists an easy way to make a barricade or a fence that would have a dual purpose of securing this from falling over and preventing people from contacting it, implied that it was foreseeable that a casually leaned pile of sheetrock should fall.
Mr. Schwartz is putting aside the merits of your 240 claim with respect to KPP. Talk to me about 240 with respect to Impact and whether they were a proper labor law defendant.
Well, my issue there is that there is an issue of fact as to whether they were, and therefore the lower court was wrong in dismissing. There was testimony that Impact brought sheetrock to the premises. There was testimony that Impact did work in apartments. So there was contradictory facts.
But there's no question that they were not the GC. The fact that they brought the sheets, the sheetrocks, doesn't make him the general contractor, right?
That's correct, of course.
Is there any question with respect to their authority to supervise, direct, or control plaintiff's work?
Yes, my argument was that that was inherent in the fact that they made an application for a building permit. And there were regulations and rules of the city of New York that set requirements for doing so. And you could see in my brief.
Isn't there?
No, go ahead, David.
Isn't there case law that the mere fact that you apply for the permit is not enough to impose 240 liability upon the entity?
Yes, you're absolutely right. However, we think that there are further facts here that.
But also, don't we look to whether or not they supervised or controlled the plaintiff's work in any way?
Yes, that's one of the factors. And here I would agree that they probably did not, because they were.
So they were not the GC. They did not supervise or control. So therefore, how would they be? How would the labor law be applicable to them?
it's not so much the label was applicable to them as their direct negligence is attributable to them. And there were issues of fact as to whether they were negligent, whether they put the sheetrock that fell.
Okay. Thank you, Mr. Schwartz. Let me hear from the two respondents.
Good afternoon, Your Honors. May it please the court. I'm Ralph Cosentino from Litchfield Cavo. I represent the defendant respondent, KPP, 107th Street, LLC. We submit that Justice Suarez got the decision right in dismissing plaintiff's labor law 240 and 241-6 claims against our clients. To begin with, the plaintiff himself was not of the type of protected worker that is contemplated by the statute, as he was not involved with the gut renovation project on the first floor of the premises where this accident occurred. In addition to his removal from the work, he was actually also on a coffee break looking for his friend to go out to lunch. The plaintiff himself was assigned to paint on a different floor. He had never worked on the first floor. He did not work in the apartment where this accident occurred. He had never worked with sheetrock. Moreover, the sheetrock, there's no indication that it should have been secured as it was being temporarily laid in an area where the work was ongoing. So it takes it out of the purview of the 241-6 Industrial Code regulation of 23-2.1A1. There's no passageway involved.
Was plaintiff a worker?
Plaintiff was a worker, but not working on the project where this alleged accident occurred. He was doing painting on a different floor. There were some floors or some apartments were being refurbished with painting and some plastering, and then there was.
But he belonged on the premises.
I'm sorry, Judge Friedman.
He belonged on the premises.
Correct, but not in the area where this accident occurred. It was a separate working area.
Why does that matter?
Well, it's a different scope of work.
I mean, he wasn't a trespasser. He was there as a worker. He wasn't there in any other capacity.
Sure, he was working in the building appropriately, correct.
So you're not suggesting that therefore he would be limited in terms of where he could go with on the premises?
Well, the expectation of the work he would be that day is definitely an issue. If he was a tenant in the building that wandered in to see what was being done on this first floor and the sheetrock fell on him, it would not protect the...
Counsel, he's not a tenant. We've established that he's not a tenant. He's definitely a worker. In fact, he's a worker of that company, and he's working in an apartment, not the same apartment, but he was doing work in one of the apartments.
That is
down to another apartment. So with those facts, why
it's perfectly natural to expect that he might go ask a coworker to join him for lunch.
Well, then even we would submit, if you suggest that he was appropriately in that area, that there's no indication that the sheetrock should have been secured for temporary leaning, as it was.
I'm a little confused. Isn't your primary argument that your client can supervise or control the work that has nothing to do with the work in that apartment, which I haven't heard you address at all, but isn't that the primary argument you're making?
We are KPP, the owner of the building.
What?
My client is KPP, which is the owner of the building.
Oh, you're KPP. I'm sorry. I'm mixing up the parties. My apologies.
So you face vicarious liability.
That's correct.
So you have to make the argument that there's no label or violation to get at.
Yes, of course.
Okay. Thank you, Mr. Cosentino.
Thank you.
Okay. Let me hear from Impact.
Good afternoon. This is Sasha Granison. May it please the court. It is our position that the court was correct in granting summary judgment to Impact on the basis that it's not a proper label or defendant. As plaintiff's counsel seems to have just admitted in his argument a few minutes ago, is that there's no evidence that Impact directed, supervised, or controlled any of the work that plaintiff performed at the job site or any work that was performed to the interior of the apartments at the job site. Impact was
counsel, what I did hear your adversary argue is that there were issues as to whether or not Impact was possibly responsible for leaning the sheetrock against the wall, or at least bringing the sheetrock in onto the premises and leaning the sheetrock onto the wall.
Yes, my client did testify his deposition that sheetrock was used in the course of the common area and hallway work that was performed at the job site. There's no evidence that my client used any sheetrock for the interior renovation work at the premises, that they stored any sheetrock to the interior of the premises. And in fact, the apartment that plaintiff his accident occurred in, the first floor apartment, it was undergoing a gut renovation. And he testified that that work was being performed by his coworker, which was also employed by KPP management. So all the evidence suggests or shows that if there was sheetrock in that first floor apartment, it was brought to the job site by KPP because they were doing a gut renovation in that first floor apartment, not my client. My client's proposals only pertain to common area and hallway work. He testified at length in regard to only bringing a small amount of sheetrock to the job site each day that they used it, and it was installed the same day. And again, they never stored any sheetrock.
See, I thought you were going to spend more time how you had little control, supervision, direct or control the work that was being done, and that's the basis on which, which relieves you of 240 responsibilities.
Correct. Well, that was part of what I was trying to indicate earlier, is that it seems that plaintiff's counsel admitted in his oral argument that Impact actually did not supervise, direct, or control any of plaintiff's work or any of the interior renovation work that was performed to the apartment. But yes, in our brief, we submit that Impact did not control, supervise, direct any of the work. The proposals only pertain to the common area and hallway work. And in regard to this work permit, as the court has noted, and as we have noted in our brief, there's simply no case law that suggests that a work permit alone is enough to establish that a party is a general contractor. Impact simply was retained to do the common area work. That's the work that it did perform. There were 4 specific apartments that were located on that work permit that they agreed to do as a favor to include on the work permit, but they actually did not perform that work. Plaintiff confirmed from his own testimony that it was him and his co-workers that did all of the interior renovation work, and that it was supervised and controlled by workers from KPP management.
Thank you, Ms. Granderson.
Thank you.
Okay, you get 1 minute rebuttal, Mr. Schwartz.
Thank you. Yes. First of all, the argument that plaintiff wasn't involved in the gut renovation, I think is an irrelevant argument. Plaintiff was clearly performing a protected activity when he was upstairs doing what he was assigned to do, which was painting, which is specifically, explicitly covered, stated in 240, or if he was plastering, that was ancillary to painting, or by itself was making a significant physical change in a building or structure. So the plaintiff, aside from the fact that he was on a break, which we've established, Morales against Spring Staging and other cases clearly state that you don't forfeit your protection when you start to go on a break if you have to go to the bathroom or on your way going to work or getting a tool or things like that. So I think it's pretty clear that the plaintiff was entitled to the protection of 240 of the labor law. There's no reason to try to separate projects. I think a separation is irrelevant.
Thank you, Mr. Schwartz. Thank you to all 3 of you.
Thank you.
Thank you.
Garrido versus de Blasio.
Good afternoon, Your Honors, and may it please the court. My name is Aaron Amaral. I'm here on behalf of the petitioner's appellant. We're seeking the reversal of a lower court decision on an Article 75 and seeking de novo arbitration insofar as the original arbitration was marred by misconduct or fraud.
Tell me,
I want to ask you, there's supposed to be a video of what transpired in the office, in Ms. Jamison's office. Did you or anyone else who represents the petitioner ever get to see that video?
I did get to see a edited version of the video after the partial video after the fact, after the discovery in the federal case, Your Honor, and it supports our argument that the video does not show that the grievant in this case, Mr. Dudley, ever entered the pool facility. The central factual issue in our defense was precisely that. Mr. Dudley, from the very beginning, at every opportunity from 2016 to 2019, argued that he was never in the facility. And the video evidence, we believe, and from what I saw after the arbitration decision was issued, should have been made available at the arbitration itself, should have been made available to the grievant, should have been made available to the union, and certainly should have been made available to the arbitrator in issuing their decision. And
Counsel, even if the video shouldn't have been considered, judicial review of arbitrations are very limited. And the arbitrator here says that she didn't rely on that because she had the direct testimony from the complaining individual, in addition to another witness. I think it's Ms. Jameson and Ms. Lagno. So why wouldn't the arbitrator's decision based on this other evidence still be sufficient?
Thank you, Your Honor. The evidence that was reviewed, first of all, we agree that the basis of overturning an arbitration decision is narrow, but it's precisely for those reasons why the fundamental fairness is so important in these reviews under 75. The arbitrator in this decision was unable to review the video evidence. What they were provided was selected screenshots of some of the video selected by the city of New York in support of its case. So while
what do you do with the fact that arbitrator Spencer, although found the failure to turn over the video to be problematic, the reality is that she didn't rely on it. Instead, she says she relied on Jameson and Lagno.
Respectfully, Your Honor, had the arbitrator had the video available to them and was able to see that, in fact, Mr. Dudley did not enter the building, this was evidence that could have called into question the credibility of Ms. Lagno and Ms. Jameson. The arbitrator was denied this evidence, whether through fraud or misconduct. This evidence was not available to the arbitrator, and we were denied the opportunity to call into question the credibility of these witnesses. Again, with regards to the selected stills of selected photos, again, that's not, it's the arbitrator says she didn't rely on it, but she's unable to speak to what impact being able to see the entirety of the video would have had on her decision, on her credibility determinations, etc.
Right. So why would we want that to occur? I mean, if she didn't rely on the video, she didn't rely on the photographs, why then would you want her to speak to whether or not that would have made a difference? I mean, isn't it at that point in time, it's moot, isn't it?
No, because
there's no consequence.
The grievant in this case was denied material evidence in support of his defense.
So when did you see this? How long after the arbitration determination did you actually see the photos?
Maybe 8 months, Your Honor.
And was that before or after the court made its determination in terms of approving the arbitration?
After.
And did your client, Mr. Dudley, did he testify at the arbitration?
He did. He did.
And so the arbitrator then was able to assess the credibility of your client as well as the other witnesses as well. So she was able to make a credibility assessment. Is that correct?
In the absence of that other evidence, which we believe was centrally material, then yes, the arbitrator made a credibility determination in the absence of that evidence.
My understanding also from your client's testimony at the arbitration, he did it to some extent admit using some of those words. Did he not say that he used those words in a friendly context? And when he made that stated those words, he was kind of doing it as a friendly context?
Your Honor, he admits using the words in the context of speaking to his coworkers at various points throughout the proceedings. He denies that the central issue here was there was a claim that there was an argument inside an office, inside a pool facility, which he always denied took place, and which he always denied being inside the pool facility at all. The video evidence.
Thank you, counsel.
Thank you.
Let me hear from the.
Good
afternoon, Your Honor. Jane Gordon on behalf of the respondents.
So about this video, I mean, a central issue here is the credibility of the petitioner versus Ms. Jamison. The petitioner says he never went into the office, and Ms. Jamison said that he did. The video would clear that up. I mean, doesn't just sort of basic fairness require that this video have been produced? Because if the video showed that the petitioner went into the office, well, how are you going to believe anything else he tells you? And if it shows that he didn't go into the office, it becomes pretty hard to believe what Ms. Jamison tells you. Now, I know in terms of upsetting an arbitrator's decision on this, it's a very tough burden for the petitioner. But still, just like basic fairness didn't require this video to be turned over?
Your Honor, the investigator searched for the video and didn't find it. But that doesn't rise to the level of the grounds on which an arbitration award can be vacated. However, that video is not before this court because petitioner never amended the petition to include it. Mr. Dudley's lawyer had watched that video. We produced that video in October 2019. And
he's claiming it backs him up. Do you contest that?
Oh, yes. I watched it because, of course, I have an obligation as a lawyer not to suppress exculpatory evidence.
Well, counsel, that was my point. That's why I was asking at what point in time they actually saw the video, because I was trying to determine whether or not that could have then been brought back before the arbitrator or brought back before the court.
Well, it wasn't, Your Honor. Now, my records indicate that Mr. Dudley's lawyer in the federal proceeding watched the video in October 2019. And by the way, all of these facts are public record in the federal proceeding, which has been dismissed. Mr. Dudley's lawyer had a copy of the video. It had to be redacted because there were children coming in and out of the pool building, and we had to blur all the children's faces. So once we did that, we provided a copy of the video to Mr. Dudley's attorney in December 2019. This petition was filed in December 20th, 2019. One would think that if that video was exculpatory, as petitioner is claiming, they would have amended the petition to get it in the record so that it would be before this court.
So that was my question. Did they have the opportunity or did they have the time to do so?
Sure, their petition was filed in December 2019. Mr. Dudley's lawyer in the federal action, and he's acting on behalf of Mr. Dudley, had that video in December 2019.
But you're saying anyhow that you've watched the video, and I know it still holds the record, but sometimes you know the case isn't about the video, and yet the most important factor is that you're saying that the video shows that he entered the office.
No, Your Honor. If I can go and explain to the court what I saw on the video, I am happy to do, even though it stores the record. There were two cameras outside the building. Neither one was positioned directly in front of the door to the building. They were positioned to the side. So what you see are people going into what looks like the entrance, but you don't see the door opening, you don't see the door closing. So you see people going in and coming out, but you don't physically see them opening the door and going in or out. And I think those stills that were pulled from the video showed that. And that's why the court found, the arbitrator said that they don't make the city's case. They're too ambiguous. You never see anybody actually going in or coming out of the door because of the angles of the camera.
Okay, Thank you, counsel. Okay, Mr. Amaral, you get 1 minute.
Respectfully, these are questions that should be left to the arbitrator. Counsel herself admitted that the video evidence does not show Mr. Dudley entering the pool facility. That was my recollection as well. I did not have an opportunity to provide that. I represent the union in this case.
But the question is really not whether, I mean, I know fairness was used. I know you used the term material, but that's not really the standard under which we're looking at this Article 75 petition, right? The question is whether there was fraud or misconduct in the failure to turn over the photos and the video. Right?
And I'll conclude here, Your Honor, but there was
that you face a very tough burden to upset this.
We understand. This issue of the video evidence was demanded from the beginning, from 2016 through 2018, at every step of the arbitration process. And it's notable that the arbitrator goes out of her way to mention it in her decision. The idea that somehow this was overlooked may not rise, we'll leave it to the court, may not rise to the level of fraud, but certainly rises to the level of misconduct based on precedent enough to overturn this award and apply the proper standard. Thank you.
Thank you both.
Thank you, Your Honors.
Hahn versus Stonehouse.
Your Honor, Richard Hahn, the plaintiff appellant pro se. May I proceed, Your Honor?
You may proceed, Mr. Hahn.
Thank you. This suit is brought in equity by the plaintiff appellant, the seller of real property, against his real estate brokers for forfeiture of commissions paid to them arising from their multiple breaches of fiduciary duty. In the pre-answering CPLR 3211A1 and 7 motions to dismiss, the IAS court dismissed the suit on the sole erroneous grounds.
So what's the effect? You agreed to have, your client agreed to have a dual agency, to have the defendants operate as a dual agent. What's the effect upon that? What's the effect of that on the claim that you're making here?
Your Honor, the plaintiff did not agree that both the defendants could be dual agents. That was the mistake that the trial court made. It's very clear from the disclosure statement that the plaintiff signed that he agreed that the Stonehouse property could be a dual agent, but that their agent, Nikki Carcati, had to be a designated sales agent. And the disclosure form expressly provides that a designated sales agent can only represent the seller and not the buyer. So the court made a factual mistake in reading the disclosure form. That's the primary.
So that's the argument that you're making, that the failure to disclose that she was contemporaneously representing Mr. Margulis as well. That's the
that and also Serge Burvey, who was one of her longtime clients that she was trying to sell the property to, and which in one of the documents annexed to the defendant's motion.
So you're saying that the firm could represent both, but the person at the firm working for you had to be representing only you, and whoever was working for the buyer would only be representing the buyer.
Absolutely, Your Honor, and that's what the disclosure statement that was signed clearly provides. There's simply, in fact, the defendants don't even deny that. In their opposing papers, they referred to defendant Carcati as a designated sales agent. And the form itself specifies what the obligations are for a designated sales agent. And yet she did not either understand or follow what the designated sales agent was. She was showing the property to buyers, including Margolius, who ultimately bought. But there's even a more egregious problem here other than the designated sales agent. And that is that there was never any disclosure to the plaintiff that if this property were sold to David Margolis, that the brokers would be hired to sell the property from the buyer. And the case law is clear that that is a gross breach of fiduciary duty, and unless fully disclosed to the seller and approved by the seller, that the broker definitely waives all claims to commissions and has to give up and forfeit all claims to commissions. So those are two basic things. I think the failure to disclose that the broker was going to be hired by the buyer to sell the properties is the egregious one. The other one is also significant, and that is that Nikki Carcetti showed the property to prospective buyers, including Margolius, and also never disclosed to the plaintiff that she had represented Margolius in a contemporaneous transaction, and she'd also represented.
So there was a pre-existing relationship. You didn't know that when you agreed to have her as a dual agent.
Absolutely, Your Honor.
Okay.
Now,
go ahead. I'll give you another 30 seconds.
Thank you. The other issues had to be raised in the brief because the trial court just said that the other issues raised were not warranted of discussion. So that's all that the trial court discussed, but we had to raise all these other issues in our brief because the trial court said they were not of merit. So that's, in case you're wondering why all those are present in the brief, it's because they in fact were decided by the trial court, but not elaborated on.
Okay, thank you, Mr. Hahn.
Thank you.
Let me hear from responding in this case.
Good afternoon, Your Honors, and may it please the court. The trial court explored and discussed the dual agency relationship in this case, but it also reviewed all of the papers, and it also found plaintiff's arguments without merit. With respect to the dual agency.
Okay, I know you respond, but what's your specific response to that the dual agency only allowed you to be the company to be a broker for both sides, but not the agent, and that it's
sure. So just to take a step back, and I will answer your question, Justice Kern, the dual agency form was provided to the plaintiff, and he's not representing anybody. He's the plaintiff pro se in this case, and he's a lawyer with 47 years of experience. But the dual agency form was provided to the plaintiff in late November of 2017, at the time when he hired my client to sell his property. And in that form, it provides for a dual agent with designated sales agent and advanced informed consent to dual agency with designated sales agents. At that time,
does it disclose that there's a pre-existing relationship with Mr. Burvey?
At that time, the form certainly doesn't. That's a standard New York form. But the relationship between Mr. Burvey and Stonehouse Properties and Ms. Carcetti was disclosed. It was disclosed that he was a friend. And the reason why this form was executed was because it was contemplated that Stonehouse would be operating as a dual agent. It turns out, and this is very important, it turns out that once Mr. Burvey became involved as a prospective buyer, which was at that time, he's also a real estate agent, and he served as his own real estate agent. That's Exhibit B to my affirmation below at the record pages 88 to 89. And this is important because it's an email that Mr. Burvey sent to my client that was forwarded to Mr. Hahn with an offer. The property was originally listed for $1.7 million. Okay, and Serge Burvey sent an email to Nikki stating, as you know, it is the type of property I appreciate and enjoy working on. Regarding potential noise at the property, Mr. Burvey states, as you know, it spoiled several sales for me on other properties in that area. It also stated, and this is critical, purchaser is a broker and is representing himself as buyer's broker. And by the way, okay, the offer contained in this email for $1.325 million was conveyed.
Who was the offer from?
The offer was from Mr. Burvey, and he was representing himself as a buyer's agent.
The argument you're making is that that the company did not act as a dual agent, that on a factual level, Stonehouse Properties was not a dual agent on this property and it was sold?
No, with respect to
Is that how it was structured?
With respect to, so there's a year-and-a-half timeline here where the property wasn't sold.
Yeah, but I feel like I'm not getting answers to any of the questions I'm asking. You still haven't answered my first question, which is a pretty basic question. Was it a dual agency that only provided that there had to be two separate brokers within Stonehouse, which I still didn't hear an answer to? And how exactly was the agreement structured? I mean, how did the closing documents provide was the buyer and the seller's broker.
Sure. Well, with respect to Mr. Burvey, Stonehouse and Ms. Carcetti, we were just talking about the form. With respect to Mr. Burvey, Stonehouse and Carcetti were the seller's agents, Mr. Hahn's agent. He didn't purchase the property. This was at the end of December of 2017. And there was advanced informed consent to a dual agency, okay, with Stonehouse Properties as the dual agent.
Have Mr. Hahn expressed concerns with respect to Mr. Burvey?
That's what he says in his complaint. But this
is a 3211, right? So do we take that as true or not?
We can take that as true, but he was fully apprised of Mr. Burvey's involvement. He received that email that I read to you. And,
but it sounds like what you said. I'm sorry. It sounds like what you said is that Stonehouse was the dual agent, and that Nikki was the agent for Mr. Hahn.
Correct. Vis-a-vis the ultimate purchaser, Mr. Margulies. Mr. Margulies was represented. Stonehouse was the dual agent representing both Mr. Hahn and Mr. Margulies.
But wouldn't that mean that Stonehouse was the dual agent, meaning that another agent within the organization had to represent whoever the buyer was?
Correct. And he did so. There's a Exhibit D, pages 92 to 93, reflects reflects that it was the offer from Mr. Margulies.
So does that mean that Mr. Carcetti had a fiduciary, that Ms. Carcetti had a fiduciary duty to Mr. Hahn?
That means that when she was a designated sales agent vis-a-vis the ultimate purchaser, Mr. Margulies, that a designated sales agent cannot provide the full range of fiduciary duties to buyer or seller. But that does not mean that Ms. Carcetti did not work for Mr. Hahn and get for her the best possible deal. This was a 1.5 year engagement. Okay, we have to understand that. At the end of 2017, okay, Mr. Burvey, the ultimate goal is to sell the property, and that's what she did. At the end of 2017, Mr. Burvey made an offer for $1.325 million to purchase the property. Mr. Hahn rejected it within 15 minutes and claimed that Ms. Carcetti didn't advise her on that.
So who spoke on the ultimate? I'm still confused here because a lot of things. You're telling me there's an email that says he's a broker for himself, the buyer. Then you're saying there's a dual. At the ultimate closing, what's the document? There are documents of the closing. Who did they reflect was the broker for each side in the transaction?
The broker was Stonehouse, and in the contract of sale, it states, and Mr. Hahn signed it, that Stonehouse is entitled to its commission. The sales agent.
Who was the actual sales agent on each side?
Nikki Carcetti was the sales agent for Mr. Hahn and procured the $1.1 million sale, of which Mr. Hahn is now trying to wrest from her hard-earned commission.
Okay, but was Ms. Carcetti contemporaneously or also representing
Mr. Margulies? Absolutely not.
Counsel, could you just back up 1 second? The question straightly. Sorry, if you could just answer the question, because Justice Kern asked you who was on either side, and you got into the whole thing about the broker's fee. You're saying that Nikki was the broker, the agent for Mr. Hahn. Who was the agent for the other side, ultimately? Who was the agent? Just answer give the name.
I wasn't evading. It was
okay. Just give the name.
It was Tyler Burvey, a sales agent operating under Stonehouse.
So there was another agent from Stonehouse who was on the other side, and then Nikki was supposed to be for Mr. Hahn. So she owed fiduciary duty to Mr. Hahn directly, specifically.
Correct, and she fulfilled that fiduciary duty.
So, counsel, I'm sorry again. When Mr. Hahn first approaches, is there not an initial contract, an initial agreement where this is all laid out in terms of whether there is going to be a dual relationship or not?
Yes, there's an
Okay, so was he not claiming that when he initially approached and when that initial document was generated, that it was not disclosed to him as to the fact that it was going to be a dual agent? It was going to be a dual agent.
It was disclosed to him.
But his claim is that that initial agreement did not disclose that. That's his claim, right?
Well, there's an exclusive right to sell agreement, and then there are disclosure forms.
Okay, and so what you've been talking about, so now we have other agreements, right? Now down the line, there are additional agreements where these individuals have expressed a desire to purchase the property and have gone and attempted to go to contract on it. Is that correct?
Just one individual.
There's one other.
Yes.
Okay, thank you, counsel.
I'm sorry, could I just ask one more question?
Sure, go ahead.
Assuming that there was a dual sales agency and Cardetti represented the plaintiff, and that gave her lesser obligations of loyalty, doesn't she still have some obligation of loyalty, which would include an obligation to disclose to him that she is going to be the broker to sell the 3 lots once he sells it, assuming everything you say is true?
Justice Acosta, I need to respond to that point because that's a very serious allegation that's made.
Go ahead.
And it's not made in the complaint. Let me be clear. It's made in Mr. Hahn's briefs, saying that there was a secret agreement to sell the property to Mr. Margulies and then have it be subdivided and resold, and that Ms. Carcetti would get the commissions on that sale. All that Mr. Hahn alleges is that there was the sale, and then thereafter, after Mr. Margulies improved the property, that Stonehouse was the broker on those deals. Okay, there was no secret agreement. There's nothing in the record.
I'm sorry. So what's the response to Justice Kern's question?
That there was no secret agreement, and that to the extent, hypothetically, that there was, it may have been disclosed. But
this is a motion to dismiss, so we have to accept the allegations.
But he doesn't. It's important. He doesn't allege it in the complaint. He alleges that he sold his property, and as this court stated in Dubs and the Court of Appeals affirmed, that the principal broker relationship is over, and then thereafter, Mr. Margulies improved the property, and then it was sold. That's totally within.
Thank you, counsel. We've had too much time already on this case. Mr. Hahn, I'll give you your minute rebuttal.
Yes. With respect to the question about who represented the buyer at the closing, the emails that are specifically quoted from in the complaint, Nikki Carcetti said right before the signing, she had brought in another broker from Stonehouse to represent the seller. Who was that person? His name was Tyler Burvey. Who is Tyler Burvey? Serge Burvey's son. Serge Burvey is her client of many years. So that's a whole issue on a motion to dismiss that has to be explored. Second of all, with respect to a secret agreement, the facts as alleged in the complaint were that shortly within days after the closing, the Stonehouse property was advertising the same property on their website from Margulies that had been purchased. So obviously without discovery, there's no way to know exactly what that arrangement was, but it's clear that that arrangement was in effect and was going forward. With respect to the agreement on the designated sales agent, I think there's been a little misunderstanding. That is a form that is at page 50 of the record that the statute requires be signed. It's not an agreement between the parties. It's a disclosure statement that the real property law requires. It's in the record. It's at page 49 and 50. Your honors can clearly see that it designated Nikki Carcetti as a designated sales agent. Thank you, Your Honor.
Thank you, Mr. Hahn. Thank you both. Last, we have Mohinani versus Charney.
Eric Berry for the appellants VJ and Harry Mohinani. The Mohinanis are minority members in a limited liability company known as LHC Club, and we are here today to request a reinstatement of self-dealing and misappropriation claims against the late Leon Charney, who is the managing member of the LLC. the court should focus its attention on page A24 in the record. Following trial, Justice Schechter acknowledged the existence of these misappropriation self-dealing claims. However, she specifically declined to address the merits of them, finding that they should have been pled as derivative rather than direct claims. However, the case law is clear that a defense that a claim that should be properly structured as a derivative rather than a direct claim is a legal capacity defense that needs to be raised under CPLR 3211A3, and if it is not, like any other legal capacity defense, it is waived pursuant to 3211E. This defense had to be raised at the pleading stage. It was not. Not only was it not raised at the pleading stage, it was not raised at any time prior to trial or even following the bench trial. Had it been raised, several things could have happened. The court, which is the presiding judge at the time, Justice Kornreich, would likely have denied it. We've listed in our brief several decisions that shows that when one member of a two-member LLC sues the other for misappropriation, it's properly considered a direct claim. And Justice Kornreich likely would have ruled in our favor. If she had not, given the closeness of the issue and given liberal repleading policies, undoubtedly Justice Kornreich would have granted us leave to replead. We cite
Mr. Berry, let me ask you, was the issue ever raised in preliminary discussions with Justice Schechter? Because obviously everyone was proceeding as if the direct claims were fine. That's what I'm surprised about, that this issue comes up after trial.
Yeah, well, if you look at the respondent's appendix at RA3, I think you'll see your answer. The respondents raised the question, not in a motion or not in an answer, but in pre-trial conference as to are these direct or derivative claims. And if you look at RA3, toward the bottom, there's a chart, and the chart makes it clear that they're going to pursue these misappropriation claims as breach of fiduciary duty claims, and it cites a decision, Apple versus LAG Corp, which is a case that I think correctly stands for the proposition that these are direct claims. Even at that point in time, the defendants never objected. The defendants never came into trial and said these are properly pleaded as derivative claims. They never responded to the letter that's at RA3 in the respondent's appendix saying we disagree. If they had, of course.
So they never came up saying this, disagreeing, I'm surprised that we are trying direct claims rather than derivative claims as they should be.
They're both, yes, you're 100% correct. If you look at the post-trial pleadings, both sides put in 2 briefs post-trial. Neither side mentioned this issue at all. And clearly, the parties were trying the claims based on an assumption.
Hold on a second. If you brought these claims as damage to your client, that your client was damaged, and ultimately under the law, your client wasn't damaged, the damage is to the corporation, whether or not they asserted that defense or not, didn't you ultimately fail to prove that your clients individually were damaged, since the damage to the corporation, whether or not the court ever gets into the law about who should have brought it or whether the corporation could have brought it? You just didn't prove your case under that scenario.
I think that's why we focused on the 2-member LLC cases in our brief. In 2-member LLC cases, the claim that an injury is first to the entity, the company, and devolves to the minority owner or the plaintiff owner is deemed to be a direct claim under the cases that we cite, and both in New York and in Delaware. The decisions that we cite on pages 33 through 34 of our opening brief and point 2 of our reply emphasize the fact that these are direct claims.
Okay, there's two separate issues. So if they're direct claims and the court would accept that argument, which obviously the court didn't, then you would have been able to establish your case. If the court rejects your analysis that they're direct claims, and the court's going to find you didn't suffer damages. So your whole argument is that you shouldn't have gotten into those issues because they weren't decided before, raised before. But ultimately, if they're claims, you don't have any damages, and that's what you decided.
No, there's no. Even the judge, Schechter, found that we may have been damaged. She didn't determine we weren't damaged. She just said that these were structured improperly. That's the whole point of 3211A3. If the defendant has the obligation to raise the argument that the claim is improperly structured. The defendant did not do it here, did not ever raise the claim that it was improperly structured. If it had been improperly structured, then we would have had a chance to fix it and amend it. And that's what the decisions that discussed at page 40 and 41 of our opening brief, point 4, that on this closed issue where the courts have been divided both here and in Delaware over years as to how to properly draw the line, you don't dismiss something with prejudice. In very similar circumstances, in a case called Stavroulakos, Justice Kornreich held that at the summary judgment stage, the defense had been waived, and even if it hadn't been waived, she would have deemed the complaint amended to conform to the proof. Now, what's underlying Your Honor's question, I believe, is an assumption that the economics would be different. Here, the economics would not have been different. Our damages are the same. We are still out 46.75% of the $1 million payment and the $1.5 million payment. When you're down to 2 members, then the fact that the misappropriation, there's a $1.5 million misappropriation at the company level is the same thing where the misappropriating member and the victim of the misappropriation are the only 2 members left. The courts simply say we're not going to overlook arithmetic reality. The harmed party here, in our case, is entitled to 46.87% of that amount. In fact, a decision by this court, which is, I think it's on page, it's called Najahar or something like that, I'm not sure I'm pronouncing it correctly, specifically held that it would have been wrong to plead claims like this as derivative claims. I did not try the case. I was not counsel below, but it's clear from, if you look through the history of the pleadings, that my predecessor, if you will, took the position that these were direct claims. It had many decisions and many authorities supporting its position, and then the defendants never raised the argument. They never raised the direct rather than derivative argument, derivative rather than direct argument. Now, tellingly, when they moved to dismiss another defendant, they did raise that argument on different types of claims. So they knew about the defense. They consciously waived it. There are all sorts of reasons that they consciously could have waived it. They may have owed money to other assignee type investors. They may not have wanted the court to allocate proceeds among the entire group. But our 46.87% claim does not invade anyone else's rights. If there are other investors, that would have, they were not members, first of all. If there were other investors that would have compelled the court to look at this as a derivative rather than direct claim, the economics from our point of view would have been exactly the same. We still would have been entitled to 46.875 of those 2 payments. And
thank you, Mr. Perry. You're way over your time.
I apologize.
A few minutes in rebuttal. That's okay. Mr. Fleming, you for respondent?
Yes, Your Honor. Thomas Fleming for respondent Zilli Charney and LHC Club. Your Honor, Justice Schechter correctly ruled that these claims were not part of the case, and they were not part of the trial that we had, either as direct claims or derivative claims. This was not an error in pleading. This was a conscious trial strategy. At the pretrial conference, I wanted some clarity because we had an accounting claim that was still out there, and their papers, frankly, were all over the lot. And Justice Schechter directed the plaintiffs to submit a chart showing the damages they were seeking for each of their claims. And that chart is in the record, RA2 and RA3, and it doesn't show any of the damages that are the subject of this appeal. None of those damages appear there, nor do any of the legal theories appear there. There is a reference to breach of fiduciary duty, and it's
but isn't that I mean, doesn't that benefit Mr. Berry's client? Because basically you're looking at the issue, not in terms of being direct versus derivative. You're looking, basically you outlining the claims. There was a breach of contract claim, which needed to be proved, the existence of an oral or written contract. Then you have all of the issues regarding fiduciary duty claims, etc. But the core question underlying that, I mean, in what I hear Mr. Berry saying is, I got knocked off, or the court ruled against me based on one principle, namely that it should have been a derivative rather than a direct claim, and that was raised at trial. So
I respectfully disagree, Your Honor. The breach of fiduciary duty in the chart is a failure to disclose, which has nothing to do with the fees taken at closing. The second is a failure to offer the same buyout deal that went to other members, and that was the heart of their case. And then the last is that there was sloppy and self-serving way in which he solicited and managed the investment. That's what it says. It doesn't mention anything about the fees taken at closing. And more important, at the pretrial conference, Justice Schechter specifically asked about that point, the sloppy and self-serving way in which the fund was managed, and asked, is that a derivative claim? And was told no. So we went to trial on this, thinking that the claim that the breach of fiduciary duty claim sought $9 million. That's the purpose of this. So we would know what we had to defend against. He's now changing his claim and saying, well, actually, I have a new theory. It was at the closing that a breach of fiduciary duty happened, and I want $200,000.
What do you say to, as I understand what he's saying, is that, look, his clients are the ones who sustain the loss, and it's not really they're not really derivative claims.
Well, I do think they are derivative claims. This was a 10-person LLC, but I also think the judge never had a chance to debate or decide whether or not this was a derivative claim within Solis versus Wolf, because no one made that argument ever. And we never had a chance.
But isn't that the problem? Isn't that the problem, Mr. Fleming? Because it seems that the underlying reason behind Justice Schechter's decision is the fact that this was a derivative rather than a direct claim. And that's not an issue that was framed either for trial or before trial.
The Justice Schechter made that observation, but I believe what she's saying is these claims aren't even in the case. They're not in the case as direct, or he didn't plead them as derivative. She's stating that these aren't in the case at all, and he didn't plead a derivative claim or a direct claim. And if you look at the claim summary, it's not in here. Nobody tried to prove damages on this at all. And in fact, if you look at the complaint here, the fees that he's complaining about were covered in the accounting claim. The complaint at record at page 45 says that he calls for Mr. Charney to account in the accounting claim for any fees taken at the closing, and the accounting claim was withdrawn. Now, we all understood that his claim to the fees rested in the accounting claim, and that was withdrawn before trial. And what he was seeking here was $9 million to undo the transaction on a breach of fiduciary duty, contract, or fraud claim. And what he's done on appeal is said, well, actually, I had a wholly different theory. And that theory, Your Honor, we had a lot of defenses to. Mr. Charney didn't profit from this investment. He lost $20 million. If the money, as they say, had stayed in LHC Club, it just would have used it to meet later capital calls. LHC Club was subject to capital calls for $10 million. And Mr. Charney and other members ponied up in order to meet those capital calls. But if the money had stayed in, they just would have spent less. So the money never would have gone to the plaintiffs under any theory. There were 10 other investors in here, so it really is a derivative case. It doesn't fit within Solis versus Wolf. But nobody ever gave us a heads up that this was a point to be made at trial, and Justice Schechter never got briefed on that, not by anybody. And that's the reason why your decision really should be affirmed, Your Honor.
Okay, thank you, Mr. Fleming. Mr. Berry, you get 1 minute. You're muted, Mr. Berry.
If you look at RA3, this is what he's referring to. This is our claim summary. Under the fiduciary duty claim, we allege, among other things, failing to disclose and obtain the Mohanini's consent to the $1 million in fees, commissions, and other amounts paid to himself. That's literally what was in the breach of fiduciary claims in the complaint, amended complaint, and marked pleadings and pretrial memorandum. We cite a decision where we are laying our cards on the table. We say this is a direct claim, as we did throughout. Under the cases we cite, Kaplan, Hecht, Sacker, it's the obligation of the defendant to raise the defense, derivative rather than direct. It did not do so. If it had,
but I believe that the court said that you failed to prove that, because the only possible fiduciary violation was the taking of the fees that are not entirely fair to the LHC, right?
Exactly. And that's and we're not, the $9 million in breach of contract claims, we are not appealing those. Those $2.5 million in fees, that she said we didn't have the right to have considered because they weren't properly structured. Those, we believe, are the claims that should be reinstated. Because, okay, thank you.
Okay, thank you, Mr. Berry, Mr. Fleming, great arguments.
Thank you very much, Your
Thank
Honor.
you, Your Honor.
Thank you.
Okay, this ends today's session of the Appellate Division First Department.
Thank you.